Any adjournment request?
May it please your lordships. My lord, I beg to mention for listing of a criminal petition, my lord. There was filed on 1 of the August, my lord. So,
Motion?
may come up tomorrow, my lord, or day after tomorrow, my lord.
Motion.
Motion, my lord.
What is the subject?
My lord, a criminal petition was filed, my lord, for direction to the CGM Kokrajhar.
Huh?
A criminal petition has been filed, my lord, for direction to the Kokrajhar PS.
For
Kokrajhar CGM, my lord,
huh?
for registering a case, my lord. For registering a case, my lord.
For registering a case.
Yes, my lord.
Friday.
My lord, Friday will be so late, my lord. Wednesday may be possible, my lord. Wednesday will be very effective, my lord.
No, Wednesday, some difficulty. Friday?
My lord, some urgency was there, that is why.
What urgency?
My lord, the main affair, my lord, we just filed, my lord, that although that affair was registered, my lord, the police is not taking action, my lord.
It is 156 only.
Yes, my lord.
Order has been passed by CGM.
Yes, CGM had directed to register the case, my lord. The police is not taking action, my lord.
Okay. Tomorrow.
Tomorrow, my
My
lord.
lord, I
Acknowledge,
wish to
my lord.
mention for listing a case for orders, my lord.
Give it to the court master.
Yes. Much obliged.
Sir, please. Prayer for listing a criminal petition, lordship, and for orders, lordship. Can it be lordship?
Give it to the court master. He will fix the date.
May I please, your lordship, beg to mention for listing of a criminal appeal, your lordship, for orders, your lordship.
Orders.
On Friday, your lordship.
Give it to the court master. He will give the date.
May I please your lordship? I beg to mention one criminal revision petition for listing on 20.
Motion.
No, my lord, for hearing.
For hearing, go to the registry. Approach the registry.
I have already approached my
Make
lord.
an application. Hearing matter, no.
My lord, I beg to mention item number 3 of today's list, my lord.
Yes.
I may be allowed to withdraw this petition with the liberty to refile because there's a major mistake.
Okay, Miss S.B. Chaudhary, learned counsel for the petitioner, has submitted that as some inadvertent mistakes have crept in the criminal petition, the petitioner wants to withdraw, petitioners, wants to withdraw the criminal petition with the liberty to file a press. You have the above submission made by Ms. Chaudhary, learned counsel for the petitioners, the criminal petition is dismissed and withdrawn, with the liberty as paid for.
May I please, your lordship? Lordship, I beg to mention for listing one criminal petition for admission, lordship.
Admission, okay. good.
Much obliged.
My lord, I have a prayer for listing of a IA, my lord, criminal, my lord.
I
In, my lord, another, my lord, criminal petition, my lord, for vacating the interim order, my lord. What happened in this case, my lord?
vacating the interim order.
Yes, my lord.
Give it to the
Court
court master.
master.
My
May please, your lordship, I beg to mention for list adjournment, item number 5 or
Item number
5. For the-
5,
Item number 5 of daily list,
on the prayer of Miss
Miss A. Burman,
A. Borman.
on behalf of
Counsel for
MPPR.
the petition, appearing for the petitioner. The case is passed over for the day.
May I please, your lordship? I beg to mention for item number 15, lordship. Lordship, kindly adjourn the matter for the day, lordship.
Okay, on the prayer of Miss
At Talukdar.
A. Talukdar, learned counsel for the petitioners. The case is passed over for the day.
Lordship, kindly matter may fix for 6th or 8th of this month.
Passed over for the day, it will be listed motion, na?
Lordship.
No
May I
issue.
please, your lordship? Lordship, I beg to mention for 4 similar criminal petition, lordship, in the admission column.
What similar?
Lordship, out of the same transaction, 9 checks were
one?
issued.
Which one?
Mentioned for listing, lordship.
Why similar then?
Lordship, similar because 4 checks were issued from same transaction, same matter. lordship.
2 criminal petitions. You want 2 criminal petitions.
4 criminal petition, lordship.
4 criminal petition. In the which column?
Admission column, lordship.
Did you
My lord,
after 15 August?
may I please, your lordship? Lordship, same prayer, my lord, for listing for a criminal petition for in the admission, my lord. Keep it up, lord.
May I please, your lordship? Lordship, I beg to mention item number 19. My lord, matter may be adjourned for the day, my lord.
On the prayer of Mr.
B. Saikya, my lord.
B. Shwekya, learned counsel for the petitioners. The case is passed over for the day. PP.
Much obliged, my lord. May it please, your lordship? My humble praise for listing, your lordship, of a criminal revision petition for orders column, lordship.
Okay,
Deeply obliged.
May I please, your lordship? Lordship, I beg to mention listing for criminal revision petition, lordship, for admission column, lordship.
okay, give it to the corners.
May it please your lordship? Your lordship, I beg to mention item number 39, your lordship. It is an order.
39, yes.
Your lordship. We have got the objection from the state and we need some time for that. Let it be fixed on Thursday, your lordship.
On the prayer of Miss
B. Soren.
B. Soren, learned counsel appearing for a petitioner, and the case is fast forward for a day. Will not fix any date, yes.
May I please, your lordship? Lordship, beg to mention item number 18, lordship. 180.
Yes,
Lordship, the matter may be passed over for the day.
on the prayer of Mr.
Amen, lordship.
A. Mena, learned counsel for the petitioner, pass over for a day, PP.
Lordship, similar prayer on item number 25.
Okay, same.
Also, I beg to mention a criminal appeal for listing in the admission column, lordship.
Admission column,
Admission.
new, fresh.
No, not trace, lordship.
Then how can it be criminal appeal admission column,
Lordship,
admission column? It has already been admitted perhaps,
yes, lordship.
then
But no, it is fixed for admission, lordship.
fix for admission. Look, yes, sir.
Obliged,
admission.
sir.
May I please, lordship? I beg to mention for listing criminal appeal, for admission column.
Admission column,
May I please, your lordship? My lord, I beg to mention for listing for criminal appeal along with an IA for orders,
IA.
my lord. Yes, my lord, for
Okay.
orders.
Daily list for motion, item 1.
Yes. May I pray, lordship? Lordship, petitioner before lordship issued a check to the respondent, lordship.
hmm?
Thereafter, that check was.
You are a bit loud,
Yes, lordship.
raise your voice.
Yes, lordship. Lordship, petitioner before lordship, he issued a check to the respondent. And thereafter the said check was dishonored. And thereafter respondent being a complainant filed a case before the CGM Kamrup Metro, lordship. And thereafter, no, someone was received. So my simply prayer is that both the person they are residing at Borpeta, lordship. So that is the issue, lordship. So if the case is transferred, both parties will be benefited, lordship. Otherwise, I have no good case, lordship. Complaint petition, lordship, page 10, lordship. So both are residing at Borpeta, lordship.
No, let
My-
us see. What is the complaint?
Complaint is 138, lordship, is the petition, lordship. Complaint petition under 138, lordship.
Complainant Borpeta.
Yes. Para 3 was the check issued by me, lordship. There is
You are Mohammed Ajal Haq.
page 30.
Hmm. No, what gives the territorial jurisdiction?
Yes, lordship.
Whether
Yes,
the court
yes.
of Chief Judicial Magistrate, Kamrup Metro Guwahati, has the jurisdiction to try the complaint or not?
Yes, lordship.
Then,
Yes, this, as per 142 and 42,
Yes.
CGM can.
uh,
So,
no, at Guwahati,
yes, lordship. That can be.
teachers,
Law
from
is-
where the check was issued.
Check was page 13, lordship, para 3. Check is issued by me. It is.
HDFC Bank, Ganeshguri branch.
Yes, lordship.
So that gives the place of
Yes,
doing.
place of jurisdiction.
Then,
And both are having account in Guwahati, but my price that both
yes,
are.
you have an account,
Yes.
but
But
this person issued
yes,
the discharge of so and so. Withdrawn at HDFC Bank, Ganeshguri branch,
yes, lord.
right?
Hmm.
And he also deposited a check in Barolam branch.
Yes, lord.
So Ganeshguri branch gives him the jurisdiction.
Yes, lord.
Then what is the?
Yes. So
Problem.
my price of both are staying in
That
Borpeta.
cannot be a ground.
Yes, lord. So for,
That at least discussion has.
yes, absolutely, lordship.
Been there for the complainant to lodge the,
Yes, lordship. Decision is against.
Complaint.
Yes, yes, yes.
and this court has the jurisdiction.
Yes, lordship. And so
Don't
my, if it is, so both, my price, so for the jurisdiction, both will be benefited, is they are staying there, lordship.
Don't think it is, you have also jurisdiction, residence here.
No, here I have said, no, here I have temporarily staying, my permanent residence is Borpeta, lordship. For business sake, I am coming here, lordship. So I have to maintain some accounts here, lordship.
So it is giving jurisdiction. No
Yes, sir.
point, no point. don't think law is settled
Yes, Lordship.
that
Only my prayer is that.
Sadanandan Bhadra,
Yes, yes, yes.
Dasrath,
Yes, Dashrath is there.
Dashrath.
Yes, yes. Yes.
Roop Singh or something,
Yes, yes, yes.
Rathor.
And again, so 16 meter is also against me,
The
Lordship.
point is,
Yeah.
and it is not that complainant is required to appear personally for accused. He can be represented in
But-
an act.
Yes, yes, yes. But accused has to come.
And
with
you are a
the-
contractor also,
Yes,
is
Lordship.
it not?
So for business sake and.
It is a government registered contractor.
Yes, Lordship.
Barpeta as well as nearby districts.
Yes. So I only prioritize both.
From his
Yes.
by giving money, by paying for life. Just because residence of the petitioner is in Barpeta cannot be. Complainant has the right to
Yes, Lordship.
institute the suit at a place
Yes, yes. Yes.
having territorial jurisdiction to try the complaint. No point.
Happen.
We'll close this. Law is settled.
Okay.
What is the point? So,
This is the only thing, this, they both are staying in the same place, so for the interest of both the part. 142 is also against me, Lordship. 42A, it is also jurisdiction lying and
can
judgment.
I
lying.
respond you?
142, 42A also, this can be told. Mostly 142 is subsection 2, it is against me.
So complainant has no problem in
Yes,
deposing here.
Yes,
HDFC Bank
yes,
branch manager would come. Axis Bank Bhorolamukh branch
yes, yes.
would come. And concerned post office Meghdud Bhavan.
Hmm.
They are the main witnesses.
Maintenance.
All of them have no problem. Now, what is the juris contours of 447? A fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto. No, that ground is not available. Some questions of law of unusual difficulty is likely to arise. That is also
That
not
is-
there.
that is not there.
An order under this section is required by any provision of this Sanhita or will tend to the general convenience of the parties or witnesses, or is expedient for the ends of justice. That is also not there.
Yeah.
Witnesses, 4 witnesses are ready out of 6 witnesses. 4 witnesses are from Guwahati.
Guwahati.
So that is, it will create inconvenience to the bank officials and the post office officials and the complainant.
Complaining-
No ground.
Yes,
Otherwise, has the jurisdiction. No point enact how much is the dishonor check amount. 5 lakh.
5 lakhs.
Hired Mr. D. Day. We are closing this.
Yes, Lordship.
Learned counsel for the petitioner. Full stop. The petitioner has filed the instant transfer petition under section 447, Bharatiya Nagorik Suraksha Sanhita 2023, seeking transfer of the proceedings of NI complaint and of a complaint case, CR within bracket NI bracket close, case number 5713 Uporot C.
Sorry, 5317.
5317 Uporot C stroke 2022. From the court of
Lordship, in our case.
Which court it has been?
Judicial Magistrate First Class, Kamrup Metro.
From the court of, have you said so? From the court of Landed Judicial Magistrate First Class, Kamrup, Metro at Guwahati, to the Court of Chief Judicial Magistrate, Borpeta at Borpeta, post of Para. The complaint case, so and so case number, has been instituted by the respondent herein as the complainant under section 138, read with section 142 of the Negotiable Instrument Act 1881, enact for short, stating that a check bearing number 000035 dated 30/3/2022 for an amount of rupees 5 lakh drawn by the petitioner at an account maintained by the petitioner at Ganeshguri branch of HDFC Bank stood dishonored on its presentation for collection by the respondent complainant at his bank, Axis Bank Limited, Borolumuk branch, on the ground of insufficiency of fund in the account maintained by the petitioner, bank account maintained by the petitioner at HDFC Bank, Ganeshguri branch, post of. Upon dishonor of the check, a legal notice was sent by the respondent complainant to the petitioner who has been arraigned as an accused, on 11/7/2022. Full stop. It has been averred in the complaint that the legal notice sent by a registered post on 11/7/2022 was duly delivered to the noticee, that is the petition accused, at his address of the petitioner at Madhurya Enclave, house number 85, near Hatigaon Police Station, Post Office Hatigaon, PIN 781038, District Kamrup Metro, on 15/7/2022. So stop. After elapse of the statutory period, the complaint was lodged by the respondent complaint before the court of Landed Chief Judicial Magistrate Kamrup Metro at Guwahati on 26/8/2022. Full stop. Thereafter, the case was transferred to the Court of Landed Judicial Magistrate First Class Kamrup Metro at Guwahati for disposal. Post of para. The ground on which the instant criminal transfer petition has been preferred by the petitioner accused is that the petitioner is a government registered contractor and is a permanent resident of Borpeta post of. The petitioner is involved in various construction works in the district of Borpeta as well as in the other nearby districts of Assam. Post of. The petitioner has further averred that the respondent complainant is also an inhabitant, is a resident of Borpeta. Also, and it is reflected in the complaint itself that the petitioner complainant is a resident of Bagmara Sor, Post Police Station, Alopoti, District Borpeta. Also, para. What is the citation of Dasrath?
Dasrath Lordship, two, for 40, 20, 14, 9.
Dasrath Rup Singh.
Yes, no, Dasrath is 2014 9 SCC 124, 129. Dasrath. And another one is
2014.
9 SCC 129.
1 minute.
And latest one is the 2016 2 SCC 75. That is also against me.
Do you have the copy?
Yes, yes. Second one is. This is against me question.
Enactment, December. Section Section 142.
2. Capital A subsection.
Of the Negotiable Instruments Act 1881, comma, after its amendment by the Negotiable Instruments within bracket amendment. No, as amended, comma, reads as under. Subsection 2 लिख दियो, subsection 2 लिख लो. explanation to লিখি দিব। On a combined reading of the provisions contained in section 142 within bracket 2 and explanation thereunder, comma, it is clear that with reference to an offense under section 138 of the Negotiable Instruments Act 1881, comma, the place where a check is delivered for collection, comma, that is the branch of the bank of the payee or holder in due course, comma, where the drawee maintains an account, comma, is determinative of the place of territorial jurisdiction. Full stop. Para. The position, the apostated position has also been elucidated by the Honorable Supreme Court of India in Dasarath Rup Singh Rathod. I like it. It was thereafter there was amendment after Dasarath.
So this is the latest, like I said, 216.
This is the latest.
I think.
Okay.
This will
As-
also cover. I guess.
Has been elucidated by the Honorable Supreme Court of India in Bristone India Private Limited versus Inderpal Singh, reported in 2016 within bracket 2, 2016 2 SCC 75. Full stop. Para. Section 447 of the BNSS as provided the High Court the power to transfer cases and appeals, full stop, for ready reference, comma, subsection 1 of section 447 is quoted hereunder. Para. On a reading of the provisions contained in subsection 1 of section 447 of the BNSS, it is evident that the power to transfer cases is exercisable in 3 situations. ABC ako লিখে দিব। Para. In the case in hand, comma, the petitioner who has been arraigned as the accused in complaint case number so and so, comma, had issued the check under reference from an account maintained by him at Ganeshguri branch of HDFC Bank. Full stop. The bank where the check was presented by the respondent complainant for collection of the check amount of rupees 5 lakh was Vorolumuk branch, Guwahati of Axis Bank Limited. Full stop. The legal notice issued after the dishonor of the check due to insufficient of fund in the account maintained by the petitioner accused was served upon the petitioner accused address at Guwahati, post of. In the complaint, the respondent complainant has named 6 witnesses whom the petitioner complainant would want to adduce on his behalf. Full stop. Among the listed witnesses, the petitioner has named himself as one of the witnesses. Full stop. The few other witnesses, 3 of the witnesses are the officials of HDFC Bank, Ganeshguri branch, Axis Bank Limited, Vorolumuk branch, and officials of Post Office, Meghdut Bhavan, and all these 3 witnesses are from Guwahati district, Kamrup Metro. Full stop. Well, having regard to the fact situation obtaining in the case in hand, having examined the fact situation obtaining the case in hand, vis-a-vis the provisions contained in section 142 within bracket 2 Negotiable Instrument Act and section 447 BNSS, this court does not find any merit in the contention advanced by the petitioner accused. Full stop. The conditions contained in clause C of subsection 1 of section 447 of the BNSS are not found to be applicable as most of the witnesses who are likely to tender evidence in the proceedings of so-and-so case number are from Guwahati district, Kamrup Metro. Full stop. As the notice has been served, legal notice dated so-and-so was served upon the respondent petitioner accused at his Guwahati address, it is not open for the petitioner complainant to allege that it would be there will be inconvenience to him to stand in the trial of complaint case number so and so. Full stop. Para. In the light of the discussion made above and for the reasons assigned therein, this criminal petition is found to be bereft of any merits and is liable to be full stop. Bit of merit, full stop. Consequently, comma, the instant criminal petition is dismissed.
But next one is also same.
Same.
Only check number will be different.
Check and off, please check for side of Karakita side, check for it.
Obviously. Item number 4.
May I please, Lordship? Lordship, this revision file under for 38, 442 TNS,
What is 19/9/2024?
19/9, 2020. The order passed by the trial court, Lordship.
What is the prayer here?
Page
We
154.
call for a record, prosecution notice, judgment. What is the judgment? DP case.
DV case, yeah.
What is the judgment? Dimple Boro. 175. Anwar Hussain, Sufia Begum. Called us against the impugn common order 19/9/2024.
24.
Let us see 19/9/2024. Okay, this one.
150, Your Lord.
150.
50. Please.
Let us read.
May I please? Both the
Plead for order on petition number so and so. What are those petitions?
The other one petition was for maintenance, Your Lord.
5960
5960 was filed for maintenance, interim maintenance.
interim.
Maintenance.
The whole issue is here interim.
No, Your Lord.
Interim maintenance.
That petition was rejected.
5960 rejected. And what is the other petition?
Other petition starts at page 151, Your Lord.
For
For residential accommodation. For residential accommodation in shared household.
residential order. DV এখন দিব কি? Okay, let us read page 150.
51, Your Lord.
150.
150.
Let us read.
Both the parties are present. Today is fixed for order on the petition file number 5960/2022 and petition file number 3357/2024. Both the petitioners were filed by the aggrieved, heard the both sides. In the petition file number so and so, the aggrieved has stated that she is drawing monthly pension of rupees 19,117. She could somehow manage her day-to-day expenses from her monthly pension, but at the present she is suffering from various ailments. As such, the aggrieved person is unable to bear her monthly expenses from her pension. On the other hand, the respondent is a government contractor.
Pension. Old lady or what?
Lordship,
Old lady, pension?
pension, old lady.
Okay.
Marriage of 1987. Marriage was 1987.
Okay. On the other hand,
the respondent is a government contractor class 1B category and his monthly income is not less than 90,000. Therefore, the aggrieved has paid for interim maintenance of rupees 21,000 per month in addition to other relief as paid for. The aggrieved has not submitted any documents to show the income of the respondent. It's learned that the respondent has to maintain his second wife and his family. As per the assets and liabilities filed by the respondent, his monthly income in the year 2022 is around rupees 48,000.
second wife means divorced or what?
Already divorced, Your Lord.
Huh?
During pendency of the
Let
divorce
us-
proceedings,
Okay, let us read.
the aggrieved was a government employee and after her retirement, she has been drawing pension. It is not stated that the aggrieved has any liability towards others except maintaining herself. In such a situation, I am of the opinion that grant of interim maintenance is not an immediate requirement of the aggrieved and same can be decided after recording the evidence of the parties. Hence, the petition file number 5960 2022 is rejected.
Rejected. So you are not aggrieved there?
No.
In
In petition number 3357 2024, the aggrieved has stated that this court granted interim relief to the aggrieved under section 18 of the DV Act, read with section 23(2) of the Act, I'd ordered it at 6/12/2021.
I'm not very familiar. Let me. 18. Protection order. Prohibit the respondent. And 23(2). Okay.
The matter was brought to the Honorable Guwahati High Court and proceedings was stayed by the Honorable Guwahati High Court. I'd ordered it at 19/6/2023, passed in criminal petition number 304/2023. The Honorable Guwahati High Court, after hearing both sides, dismissed the petition. I'd ordered it at 7/3/2024 and accordingly the stay was vacated. The aggrieved has stated that during the period, she was thrown out by the respondent from her matrimonial home and never allowed her to come back. The aggrieved has been taking shelter in her son-in-law's house and thereby she has been aggrieved of right to residence from her shared household. Hence, the aggrieved has prayed that respondent may be directed to allow the aggrieved person to reside at her matrimonial home shared household. That is flat number so and so, so and so. In response to the petition, the respondent has filed written objection. He has stated that the aggrieved was not thrown out from her matrimonial home. Rather, she had willingly left her matrimonial home and kept on staying in her different relatives' houses. Moreover, their marriage has been dissolved by Qazi on 23/6/2022 following the provisions of Muslim personal law and thereafter divorce has been duly registered on 25/1/2023 by Qazi Muslim Marriage and Divorce Registered. Against that registration of divorce, the aggrieved preferred a petition before the Honorable Family Court, Kamrup, Guwahati, which is still pending. Apart from that, the respondent begs to submit that the aggrieved person on multiple occasions taken undue advantage of protection order passed by this court and tried to brutally beat and torture him in collusion with her daughter and son-in-law. In this regard, the respondent had lodged an affair on 9/6/2023 before the Dispur police station, and another similar affair was lodged on 21/10/2021. With this, the respondent has denied all the allegations leveled against him by the aggrieved and prays to dismiss the petition. It's prima facie proof that the aggrieved has domestic relationship with the respondent. Divorce or dissolution of marriage is not a factor to deprive the aggrieved from the relief prescribed by the DVA. Section 17 of the PWDVA Act specifically lays down that notwithstanding anything contained in any other law for time being in force, every woman in domestic relationship shall have the right to reside in the shared household, whether or not she has no right, title, or beneficial interest in the same. In view of the above provisions of law, it can be said that the aggrieved cannot be deprived of her right to residence in her shared household. It is learned that the aggrieved has not been allowed to reside in her matrimonial home by the respondent. As per the version of the respondent, he did not drive out the aggrieved from the matrimonial home. Instead, the aggrieved, in her own wish and volition, left the matrimonial home and staying with her daughter and son-in-law. This implies that respondent must not have any objection to provide accommodation to the aggrieved in her matrimonial home. Since the aggrieved has no permanent residence of her own, it is the duty of the court to provide her shelter so that she can smoothly live her life with respect and dignity. Hence, I am inclined to allow the petition. The respondent is directed to provide adequate accommodation to the aggrieved in her matrimonial home, shared household, until further order, or arrange a rented house for the aggrieved as alternative accommodation, and house rent up to 8,000 shall be borne by him until further order.
Then in the judgment,
In the judgment, operative portion started.
so evidence of PW or etc. next date. So it is an interim order.
It's an interim.
It was an interim order, and this appeal was only against the interim order.
Interim.
So what was the
Judgment.
judgment?
174.
Affirmed or
Partly allowed,
Reversed.
partly rejected. Yeah.
appellant claims?
Operative portion started page 183.
So- So you got the divorce,
Yes, Lord.
so-called divorce through Kaji.
Through Kazi, Your Lord.
Where is the
Which is
order?
registered.
Kaji?
Kazi divorce certificate is page 72, Your Lord.
Page
72.
72. This is a national emblem. Kazi uses, that itself goes. He uses national emblem.
Yes.
That itself is bad. No sanctity.
He was appointed by a statute, Your Lord.
Doubtful.
By statute.
Doubtful proceeding.
Assam.
Doubtful proceeding. This is under challenge now in a title suit.
It's under challenge.
So what the appellate court says or
Appellate
revisional court?
Court at page 174 and except 24.
Point for determination.
Point for determination.
Appellant
May I read?
discussion state. Agency is really need of or but there is no domestic relationship. This kind of talaq is
Believe Your Lord.
rejected by the Supreme Court?
No, Your Lordship.
Huh?
Supreme Court declared unconstitutional only the talaq a biddat, Your Lordship.
And this kind of divorce certificate, can it be issued?
Yes, Lordship. It's a Supreme Court itself.
Divorce certificate is to, he can only register.
No, Your Lordship said.
He can only register.
Yes.
He cannot issue a divorce certificate.
This is certificate as per.
He
Lordship.
cannot issue, and now that the act is also repealed,
Yes, Lordship.
divorce certificate.
Prior to that, Your Lordship, all proceedings and all the right and
25,
equal
74.
75.
Judgment starts at page 70.
70. One year,
Yes.
9 lakh.
1 year, 9 lakh.
Then what is the appellate court? Where is the
Appellate
appellate?
court has upheld the judgment.
Where is that judgment?
It starts at page 20. The judge-
20.
20. The order is in page number 37.
Final conclusion. 8 lakh, check was 8 lakh.
2 checks were there, 4 lakh. each.
Total
Total
8
8
lakh.
lakh.
So,
Your lordship, my contention is that your lordship, the entire transaction, this is not a transaction which is legally enforceable. So the presumption was generally initially under 139 of the act is that the transaction is a legally enforceable transaction. But in this case, your lordship.
why?
Because your lordship, the complainant in this instant case, his whole premise and the case has been made out on the basis of a promissory note. The promissory note is at page number, if your lordship may kindly turn to page number 43, that is the typed copy, and 44 is the original document.
Okay, now, did he exhibit it or not, complaining?
He exhibited it.
Let us see his part. To pay 8 lakh. Pay 8 lakh. Consider a request. 8 lakh. Okay. Then let us see his cross-examination.
Cross-examination is page number
Did you
67.
question him?
I questioned him and
Let us see. Page 67.
67.
Did you adduce evidence?
No, your lordship, I did not reduce it.
Then what remains?
I gave my
what
statement,
remains?
I recorded my statement and the section, a statement is recorded, it's
313.
313.
Simple denial, but
Simple
presumption is there for for rebuttal of the presumption.
Your lordship,
What can be taken from the evidence on record?
your lordship, if I may.
No, let us cut short.
Yes, sir.
I have not found anything.
No.
So what is the amount you can deposit?
20% I can deposit instantly, 20. But your lordship, one point I just like to mention in here. In the cross-examination, he has stated that the mode of transaction, when you have asked him about the mode of transaction, he has stated that the mode of transaction is mentioned in
That
the
is not
promissory note.
going to the root of the
But your lordship,
issue.
as per the,
Compliance was there, check was not denied, it was under your signature. Deposited correctly, timely. Timely,
timely. deposited.
demand notice served timely. Proceedings initiated timely. Then thereafter only there was some change in the date in mentioning by the complainant. But he exhibited the document. Mode of transaction only. That is the issue only.
Because
Nothing
your
else.
lordship, the transaction as per the income tax.
Nothing
Act-
else, Mr. Counsel.
But your lordship, as per the income tax, Act, any transaction which is above the amount of 20,000 rupees cannot be made through cash. And in this instance, he has
That we
neither,
examined later on, but it is not. Show me. What was the date of the transaction?
date of the transaction,
2020.
2020. The check date for
You did not question about his capacity to pay.
your lordship, the
You did not question his capacity to pay. The complainant's question to capacity to pay 8 lakh. There was no question about it. You did not ask anything. Now what is that?
I may be wrong,
Ah.
but your lordship, the, when the question
He
was put up,
gave it
regards,
and you also executed the promissory note. Now you are trying to reverse the clock when you were a party to it. Show me the authority. What authority you are relying upon? At this stage, the question is only suspension of the sentence, nothing else.
is the income tax, as I will come. Because the transaction in here, he has not,
Okay, show me the authority.
your lordship, okay, I will. So
What
this is
what
the law.
has flown after that?
I will,
This issue has been dealt.
I will show you authority, your lordship. This is a Kerala High Court judgment. If that will not be binding, but for reference purpose, I will show that Kerala High Court judgment.
There was no ground, no question,
I admit it, your
no
lordship.
question at all during the
But your lordship, when I
entire
asked
proceeding.
regarding that mode of transaction, my intention, though it might not be explicitly, but the mode generally and the transaction, your lordship.
What is not there, we cannot read into it.
Yes, your lordship.
So far as evidence is concerned and concurrent finding of fact is concerned.
That I admit, your lordship. I know.
We cannot legality, correctness, propriety and revisional jurisdiction is very limited scope.
Limited.
What you did not ask him, we cannot read.
They didn't do. But your lordship, inherently when a transaction is,
That is ifs and buts. You did not ask anything.
but your lordship, the
Now,
fact
now
that I
at
have
the
the mode-
revisional stage, after appellate stage is over, the revisional stage, I don't think.
the cross.
How much
your
you
lordship-
can give?
your lordship, is there.
25%. You deposit 60 days. Deposit before the registry,
Your lordship, will it be possible to deposit 20%?
Huh?
20%.
25%. You have made the complaint to wait for so many years. Heard. Mr.
GR the third.
G.R. Dotto, Learned Counsel for the revision petition. Full stop. The instant revision petition is preferred to a sale. A judgment. An order dated 25/6/2025. Passed by the Court of Learned Additional Session Judge Dibrugarh, within bracket appellate court, in criminal appeal number 23 within bracket 3 of 2024, whereby the appellate court has dismissed the appeal, affirming the judgment, affirming a judgment and order dated 25/6/2024. passed by the Court of Learned Chief Judicial Magistrate, Dibrugarh, in NI case number 136/2022. Full stop. The case, the complaint case, NI case number 136/2022 was instituted by the respondent herein as the complainant, alleging commission of the offense under section 138 of the Negotiable Instrument Act on the ground of prisoner of a check amounting to rupees 8 lakh. Two checks amounting to rupees 8 lakh in total, issued by the petitioner on an account maintained by him. Full stop. The trial court has found the petitioner guilty of the offense under section 138 NI Act, and the petitioner has been sentenced to undergo simple imprisonment for a period of 1 year and to pay a fine of rupees 9 lakh, in default of payment of fine, to undergo simple imprisonment for a further period of 6 months. Full stop. Issue notice returnable and 4 weeks. The case records of so and so be called for. I do for deliver as the petitioner shall take steps for service of notice upon the respondent. Returnable in returnable on after exactly 60 days. Exactly 60 days. Heard the learned counsel for the petitioner on the interim relief, on the interim prayer. Full stop. The learned counsel for the petitioner has submitted that under section 269 SS of the Income Tax Act 1961. Any amount beyond how much? 20,000. 20,000, has to be transacted through a check, account pay check, or bank draft, or through the use of electronic clearing system. First off, when the complainant was questioned or was cross-examined, he stated that the mode of transaction was mentioned in the promissory note executed by the petitioner and exhibited as Exhibit 1. Poster. But in Exhibit 1, there was no mention of the mode of transaction. Poster. The issue can only be considered at the time the issue raised here can only be considered at the time of hearing. Poster. Be that as it may, the petition as it is submitted on behalf of the petitioner that subject to reasonable deposit, the execution of the sentence passed against the petitioner be suspended. To stop. Having regard to the provisions contained in section 148A of the Act and the fact situation obtaining in the case in hand, this court is of the considered view that subject to deposit of 20% of the fine imposed by the learned trial court as well as the appellate court. That is, fine amount of which 9 lakh. That is, whatever. Within a period of 60 days from today before the registry of this court, this court is inclined to suspend the execution of the remaining part of the sentence passed by the trial court and the appellate court. Full stop. It is accordingly observed. Full stop. Meaning that the petitioner shall deposit a sum of rupees so and so before the registry of this court within a period of 60 days. Full stop. Subject to deposit of the said amount of rupees so and so. It is ordered that the remaining part of the sentence passed by the so and so shall remain suspended till disposal of shall remain suspended till the returnable date.
1510.
Full stop. Further orders will be passed on the further order on the interim prayer will be passed subject to placing the receipt of deposit of the aforesaid amount.
1510.
Briefly, please.
Item 7.
May I please, your lordship. Lordship has already heard this matter on 31/7. The issue relates to section.
Hold on. Yes,
Yes,
what
the
is
issue
it?
relates to section 223 of BNSS, whereby there is a provision, new provision to hear the proposed accused prior to issuance of, prior to taking cognizance.
What is the complaint?
The complaint, your lordship will find that page starts from page 94 and runs up to 98. My primary contention is that, lordship, it's a civil dispute which has been given a criminal color. And the impugn order, your lordship will find at page 99. On last occasion, in fact.
Let us see the dispute first,
Yes. Para 7, your lordship will find.
because everything cannot be civil. There may be criminal element also.
Yes,
Let
here
us
is a
see, let
case.
us see, let us
Yes,
see.
here is a case, lordship.
Let us see the complaint.
Lordship, that page 94 starts from 94.
So your mother sold a plot of land
Yes, to the petitioner number 3.
and,
Who is the defendant number 2 in the title suit filed by the complainant.
and what was the claim in the title suit of this?
To cancel
That,
the registered sale deed executed between the mother of the complainant and as well as between the petitioner number 3.
Sale deed
Yes, which is the
or
subject matter.
agreement for sale of land.
Agreement for sale as well as registered sale deed.
Where is the registered sale deed? Part of this.
Yes, Lordship. At page 37, your Lordship will find the agreement for sale.
This is agreement. Because you have changed the agreement on the next occasion again. Thereafter a sale deed.
Lordship.
The story is different.
Yes.
One agreement for sale of deed, then followed by another one, then followed by sale deed. And you have changed the consideration. That is one, but where is the sale deed? Where is the plaint?
Plaint, your Lordship will find at page 15. The cause title of the plaint, here the defendant number 1 is the mother.
Sale deed agreement for sale and deed number 2004-2023.
Yes.
Then it might be part of your record.
Yes, Lordship.
To us.
That page 4950, Lordship.
49. It is the sale deed.
It's a deed of agreement for sale. Dated.
Hard, Mr. Yes. Huh?
It's a private complaint.
Hard, Mr. R. Bora. Counsel for the petition. Post of in this criminal petition. Filed under section 528 B and SS. The petitioners, three number have sealed an order dated 18/12/2024, passed by the Court of Learned Judicial Magistrate First Class, number 5, Kamrup Metro at Guwahati, Trial Court, in CR case number 690, Part C, stroke 2024, page 99. Poster. By the. What is the provision here? 213 or what?
This order is issued in terms of 223. Yes.
223, Lord. 223. By the order dated 18/12/2024, Command General Trial Court. After hearing the petitioners as proposed accused persons under the provisions of section 223 BNSS, comma, has observed that there is sufficient materials to proceed with the complaint, and the case will be decided on merit, the basis of the facts found on initial deposition and evidence. First of para. The copy of the complaint is found annexed at page number 92 to 98 of the case papers. First of, in the complaint, comma, now 3 petitions herein have been arraigned as the accused. First of, para. The petitioner number of the petition number 3 or 1 is the mother of the respondent that's complainant. Full stop. According to the respondent complainant, comma, both of them inherited a plot of land. Full stop. But the petition number 1, that is the mother of the complainant, respondent complainant, has surreptitiously entered into a sale transaction.
Lordship, the mother of the complainant is not before your lordship.
Huh?
Mother of the complainant is not before your lordship because the mother of the complainant has not been arraigned as a
Okay, okay.
accused. Petitioner number 1 is a
Okay,
different
okay.
person.
Sorry. In the complaint, comma, the respondent complainant has alleged that she and her mother Padma Mahanta inherited a plot of land after the demise of her father. Post stop. The respondent complainant has further alleged that the petition number 1, by exercising deceit, 3, by exercising deceit, and entered into a sale transaction with the respondent complainant's mother with regard to the said plot of land by executing a sale deed fraudulently, and other 2 petitioners had assisted the petition number 3 in such acts. Full stop. The the respondent complainant has already instituted a title suit, title suit number
62.
3/2024 before the Court of Language Civil Judge number 1, Senior Division, Kamluk Metro, Guwahati. And the suit is for declaration, partition, recovery of possession, cancellation of agreements of sale, including the sale deed executed in respect of the plot of land under reference. Full stop. The said suit is pending as on date. Full stop. Para. Issue notice returnable. 4 weeks. The matter would require consideration, written notice, returnable petition subjects steps for service of notice upon the respondent by trace that proceed AD as well as by usual process, having regard to the projections made on behalf of the petition and after going through the contents of the complaint, comma, and the and considering the fact that the tail deed and the reference was executed between the petition number 3 and the mother of the respondent complaint before the senior sub-register Kamrup Metro Guwahati on 19/4/2020, it is ordered, in the interim, then further proceedings of so and so. Case number presently pending before the so and so shall remain suspended till the returnable date. Oh.
May it please you. There's an application also against the order rejecting the.
Yes, do you have any reports?
My lord.
Do you have report?
My lord, I have report regarding my lord gold.
Gold, no,
This
we
is
are on
the-
currency.
Gold order already Zimma has been given, your lordship, this order was there. I have also annexed the order of the gold in this petition itself, that is at page 65. In that case also, a line has been stated with regard to the cash. Page 65 for a moment, your lordship. This is the gold part. And in paragraph 6, your lord, the court has stated that.
How can it be a conclusive finding?
Which one?
Paragraph 6.
6, your
There
lordship.
cannot be a conclusive finding.
No, it's
Prima
not a
facie-
conclusive finding, but
It is conclusive finding.
no, it has been
Order
stated
to
that
nine.
the money was recovered from so and so was actually
Court
given by
said-
the petition.
Paragraph 6.
Yes. In the paragraph 6, page 66.
I have
Yes,
read.
that is what the court
66.
said. The court is satisfied. But the money that was recovered, this was with regard to the.
We have the report of currency.
And secondly, your lordship, whatever be the reason, let it be not conclusive also. Then also, your lordship, in this case where money is, your lordship, recovered or seized, then the procedure has already been laid down in the case of Sundarbhai Ambalal Desai. It has stated, your lordship, how and why the court should return the money and how it should be done. That's yes.
Yes, sir. We have
Yes,
the
my lord,
report.
whether my lord that rejection order is my lord before search sheet or my lord after search
No,
sheet?
no, sheet has been filed now. It has been filed.
Section 451 is during inquiry or trial.
My lord.
I think section 451.
Well-
PNSS
Yes.
government provision, it is during inquiry or trial.
Yes.
My lord.
451 is applicable.
Now, charge sheet has already been.
Do you have the report or not? There has been.
My lord, regarding money, my lord, report
Yes or no?
is not here, my lord, today.
It has been repeatedly called for
Yes.
My lord.
since 28/5.
And.
Call for a fresh report. That is what. There is an order and that has been repeated
My
Yes.
lord.
in subsequent orders. 4 occasions.
My lord. My lord,
Have you sent the communication or
my
not?
lord, communication is, there is already communicated, my lord, more than 2 dates are there, my lord. My lord, LCR is also called for, my lord.
I think LCA has come.
LCA is called for, but report, after a detailed order, a press report has been called for.
My lord.
then we cannot overlook that order also.
My lord. And then, my lord, I have to take the, my lord, just short date, maybe next week, my lord, I will collect, my lord.
There is office to issue a fresh reminder.
My lord.
Now case LCR received. You said that you have received a report.
That is, my lord, regarding gold.
Then why did you say so?
No, my-
On the last occasion, he was not there. My learned friend has
Mr.
said
Borua was there.
already, your lordship, the charge sheet has been given. That is, I think the records will reveal. Can copy. Charge sheet has also
Next
been.
Tuesday then, heard
My
U.S. Mandan, Learned Counsel for the petition, and Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent state posting. Having regard to the prayer for interim custody for the case amount of rupees 22,70,000, this court on 28/5/2025, call for a fresh report from the concerned investigating officer of STF Police Station case number 07/2023. Post of, despite subsequent orders dated 16/6/2025, 25/6/2025, and 25/7/2025, the report from the concerned investigating IO regarding the currency amount has not been placed before this court. Post of Mr. Sharma, Learned Additional Public Prosecutor, has sought a last opportunity of 7 days to place the report. Post of, as sought for this, the case next Tuesday.
12/8.
Next.
To 12, my lord.
12/8. Item 9.
One minute, Mr. Manan, issue notice returnable on next Tuesday. And issue notice as agreed by the parties, that notice is made returnable on next Tuesday. Next Tuesday, returnable. One copy. Huh? Step. Mr. Manan, serve a copy by tomorrow. Petition. Serve a copy by tomorrow, so that we'll dispose of in the admission stage.
No, I'll serve it today. Let us copy.
I have passed order. Yes, Mr. Goswami.
Lordship, here, my lord, a report has been called for regarding the CD, my lord. The case
Status
is,
report.
yes, status report, my lord. Actually, what happened? The case was first in the Oloman PS. Thereafter, it was transferred to Bodorpur. Now, my lord, as per the my lord, IO's report, my lord, the case was at that time handled by one IM, my lord, my lord, SI D Nath, my lord. She was the IO at that time, my lord. After deliberation, my lord, it could not be found out, my lord, where the now CD is, my lord. That is the substance of the report. But, my lord, I'm today, my lord, I'm reluctant to give this report, my lord, because there is a pair. Just because of the last paragraph she has mentioned, my lord. So
Not happily ordered, then she should come.
otherwise, my lord,
Not happily ordered, she should come.
because it was addressed to me, my lord, that is.
I think officer in charge is the first responsible officer.
Yes, my lord, that is, the report
of
has
the
been given by
All-Women
my
Police
lord.
Station.
Yes, report has been given by
Anything done by subordinate.
lordship. And my lord, the letter is
Responsibility also cast upon them, obligation
lordship, yes,
to answer.
lordship.
Why should we call another subordinate official or constable or all?
Yes, my lord, that,
I think the police officer who is in charge of the police station,
yes.
she should be answerable.
That is, that the letter addressed to my
Let
lord,
the
public
officer
prosecutor.
in charge come.
Lordship.
This is no record found, but this is an order. According to this report, transfer order was passed by the Court of Subdivisional Judicial Magistrate
Lordship.
on 19/7/2020.
Lordship. Yeah, and my lord, at that time, as per the report, my lord,
So, Mr.
Whether, my
Goswami,
lord-
what should we record?
that is what my lord, and my lord, I'm also not clear, my lord, whether when she joined, my lord, regarding OC, my lord.
Whatever.
Lordship.
Heard Mr. D.K. Nath, learned counsel for a petition, and Mr. M.P. Goswami, learned additional public prosecutor for the response number 1, state of Assam. Post of Mr. Goswami, learned additional public prosecutor has submitted on the basis of a report received from the officer in charge, All-Women Police Station, that though all available records have been searched, no record transferring transferring the records of All-Women Police Station case number 163/2019 could be found. First of para in view of the above submission made by internal and additional public prosecutor, and in deference to the previous order dated 31/7/2025, the court is constrained to call for personal appearance of the officer in charge of All-Women Police Station, Panbajar. Post of and the case on the next date of listing, post of the case is let the case be listed on 18/8/2025 for personal post of the officer in charge, All-Women Police Station, Panbajar is directed to appear person on that day. Post of a copy of this order furnished to Mr. Spencer for taking necessary steps from his end.
Yeah, and also a fresh report, my lord, whether what had happened. And also a fresh report we can call. Also.
It is up to
Lordship.
now. Everything will move fast.
Lordship.
Item 10.
Mr. Bro will issue notice at this stage. Yes. We cannot doubt their appearance, but law,
Otherwise, your lordship.
whether the law has been settled regarding the date of remand.
Yes, your lordship. Law is settled.
Law is settled by which judgment?
By this judgment of Ravi Prakash Singh versus State of Bihar.
Let's put this.
Date of remand
Date of remand.
is to be included.
Date of remand has to be included, and also the 68th day. Now, here in this case, your lordship, on last operation on Friday, I forgot to mention one important aspect. One important aspect is that this prayer for default bail has to be considered.
Ravi Prakash, no, thereafter much water has flown, Mr. Bora.
Your lordship, that is the law because.
No, that is the law. Then there on this issue, many judgments.
Your lordship, that
This
is
way, that way. This way, that way.
because if I take your lordship to paragraph number 10, 11 and 12.
No,
Which
While, Robi Prakash Singh, mobile gun.
Ravi Prakash Singh versus State of Bihar. This is a 2015 judgment. 2015 SC 1294. And paragraph number 10, 11 and 12. But nonetheless, your lordship, what has actually happened?
No, it's 2023, 15 FSC, 323. Right, default bail 167.2. Proviso A. Whether while computing the period of 90 days or 60 days, the date of remand is to be included or excluded for considering a claim for default bail.
Yes.
And it is observed there being divergence of opinion as some judgments favoring the exclusion of the date of remand, while few other cases took a contrary view, the issue be referred to a larger bench for an authoritative pronouncement. Therefore, the registry directed to place all the relevant documents before the Honorable Chief Justice for constituting a bench of at least 3 judges to resolve the conflict in law on the issue of grant of default bail. So all these Ravi Prakash, all these things have been included.
Your lordship,
So come up with the better thing.
your lordship, if I may, your lordship, if I may submit one important aspect.
But it is ultimately, if we go by the concept of par inquirium,
Yes.
then it is Saganti Satyanarayana, 1986 judgment. That may prevail. If I, then 2024, 3 SCC, 74. After that, Kopil Badwa, 1 minute. Now, just minute. I don't know whether it has been referred to the larger bench or not. We are in 2023-24 situation,
23.
not 2015.
Your lordship, also one important aspect, your lordship, which actually I forgot to actually mention on Friday. This prayer for consideration of default bail will have to be considered always on the 61st day.
That I know.
That your lordship, here also in my respectful
That
submission.
if there is applicability of the General Clauses Act, then
General
only,
Clauses Act.
then only on 61st day. Otherwise, it was technically speaking 61st day
61st, no, your lordship.
or 62nd day maybe.
Because if I may take your lordship,
Saturday and Sunday, whether that will come in or not, that is another issue.
your lordship.
That has been, we'll issue notice at this stage.
Yes, your lordship.
Mr. Goswami, you assist
Yes.
somebody. Yes, Mr. Gogoi, public prosecutor. Though you are not a party here,
Lordship.
tell me, what is the latest law?
At present,
Whether the
lordship,
date of remand is to be included or not to be included?
that part lordship already as per full bench, it was referred to the lordship, the larger bench lordship,
Place me,
larger bench lordship.
place before the court.
Lordship,
And secondly,
lordship,
if the day, 60th day
lordship.
is Sunday,
Sunday, or then which previous day will be counted or later date will be counted, lordship. That
or
part,
whether Monday,
lordship, or
filing of charge sheet on Monday
lordship.
will fulfill the condition
Lordship,
of filing the charge sheet on 60th day.
lordship.
These are the issues.
Lordship.
Now here, if we go by the doctrine of concept of par inquirium,
Lordship,
then it is one soganti.
lordship,
It says date of remand is to be included
lordship,
and subsequent decisions.
lordship,
Somewhere it is remarked
lordship.
that if soganti is not considered, then all subsequent decisions will be par inquirium.
Lordship. We will
And
find out,
secondly, somewhere it is said General Clauses Act will not come in.
lordship.
So I am also confused.
We'll find out, lordship.
But the
We'll try to
statute says something different, your lordship. Section 10 of the general
No,
clauses. Act.
General Section 10 General Clauses Act, no, it says, no, it does not say about submission of charge sheet.
No, it doesn't.
That has been
But-
interpreted somewhere.
Yes.
What to do for
Yes.
us?
In, it says that computation or when by any central act or regulation made after commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed
Here
period.
was directed allowed to be done.
Then if the court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall.
Now, Mr. Bora, somewhere it is said, I have seen any act or proceeding
Yes.
that will not include submission of charges. Somewhere it is said. So it has to be placed before the court for consideration, otherwise it will be very difficult.
Also, section 471 of the CRPC.
Section
471 of the CRPC.
No, but by the previous decision in Kapil Wadhwa, it was forwarded for larger risk consideration. Thereafter Kapil Wadhwa has been decided, but I don't know what has happened. But Kapil Wadhwa itself, previous order, it has referred to the larger bench. No, mister, this is the problem. As per Kapil Wadhwa, but again,
There is a judgment of 1984, my lord. It says, my lord, only if it is holiday, my lord, subsequent date, yes.
please,
But,
citation,
my lord, I have written as criminal miscase, my lord.
690.
Supreme Court.
Supreme Court, my lord, 696. I'll place it, I'll just.
No, so we, I'll read it.
696 of.
Criminal miscase number 696, 1980.
You heard Mr. D. Bora, Learned Counsel, Learned Special,
Senior Standing Counsel, DRI.
Senior Standing Counsel, Enforcement, or DRI,
DRI.
DRI, for the petition. Poster. Laying a challenge to an order dated 13/5/2024.
Yes, your lordship. As well as the criminal revision 24/3/25.
Okay. Mechanically cook. 35/2024 passed by the Learned Chief Judicial Minister, Kamrup Metro, Guwahati, in Annexure 2, in DRI case number so and so, page 96. And the subsequent order, page
Page 85.
85. Subsequent judgment dated 24/3/2025, passed by the Court of Learned Additional Session Judge number 2, Kamrup Metro, Guwahati, the Revisional Court, in Criminal Revision number 36 of 2024. Affirming the order dated 13/5/2024 Supra, the instant criminal petition has been referred post up. One of the questions raised, one of the issues involved is whether the date of remand comma 14/3/2024
Yes, your lordship.
is to be included or excluded for considering a claim for default bill. For considering, post up. The another issue which has been raised is that as if the 60th day is a public holiday,
Public. holiday.
then submission of a charge sheet stroke complaint on the next working day would be sufficient for compliance of for submission of the charge sheet stroke complaint in view of section 10 of the General Clauses Act and section 471 of the
CRPC.
CRPC. Post of issue, no matter would require consideration, issue notice returnable on so and so date. The petitioner shall take steps for service of notice upon the respondents by registered proceed AD as well as by usual process to render assistance to the court. Mr. K. Gogoi, learned public prosecutor, State of Assam, is requested to assist Mr. So-and-so in view of the issue. Question involved, Mr. Gogoi, and additional public prosecutor is requested to render assistance to the court. The name of so-and-so be reflected in the
Lots.
call list.
Apologies.
Okay,
3rd
copy,
September.
Mr. Bora, you give it copy. Mr. D. Bora, and so-and-so. Please request, we shall furnish a copy of the criminal petition along with annex to Mr. Gogoi. We need to work in this one.
Lots.
3 lines.
No, this issue is will come up again and again.
Lots.
Supreme Court is not
Conflicting
clear.
view is there also.
not very clear.
Lots. Apologies.
Item 11.
Please, Lordship. Lordship, this was filed regarding the zip of coal.
Report, something report was called for.
Today I am praying for a date, my lord. I received some verbal instruction. I will produce the report, my lord.
Okay.
On
Next
11,
My lord,
Next week,
next, yes,
may I pray for 11th, my lord?
not 11, something else.
lords.
Not 11, any day after 11.
My lord, I'll tell the court, my lord, as per my lord's convenience.
Mr.
Jay Singh, lord.
Jay Singh. Heard Mr. Jay Singh, learned counsel for the petitioner. MP Goswami, learned additional public prosecutor for the response number 1 from State of Assam. First of Mr. Goswami
11.
has submitted that he would need 1 week's further time to obtain. The copy of the report
Along with documents, my lord, that auction documents.
to obtain the necessary instructions in deference to the order dated 28/7/2025. First of, as the matter would require consideration, let notice be issued as agreed to by the learned counsel for the parties. The notice is made returnable on, you say, the
19th, my lord.
19th. One copy you give,
Lords.
Lordship.
one copy. On the petition, furnish, as Mr. Goswami has appeared and accepted notice on, has already appeared and accepted notice on behalf of the respondent number 1, State of Assam. The learned counsel for the petition will furnish an extra copy of the given petition along with the annexes. Mr. Goswami by tomorrow.
19th. Hello. My lord, status quo order was passed.
Last day, the early order of status quo. As on date, obtaining as regards the seized coal and the reference is to be maintained.
Item 12.
Here, we are challenging the order whereby, my lord, we have been implicated as additional accused, my lord, during the trial under section 319 of the CRPC.
319,
My
let
lord.
us see the order.
That is at page number 47.
Yes, let us read.
Today is fixed for hearing on petition number so and so. Accused Dulal Chandra Das is duly present. On 5/9/2024, learned additional PP filed a petition by number so and so under section 339. It should have been 319, my lord, of CRPC, stating that PW1 Ramesh Chandra Das during his examination in chief and cross-examination clearly stated that one Hemanta Thakuria was also involved in the crime along with two other accused persons. And in the FIR, the name of Hemanta Thakuria was mentioned as one of the accused persons, but at the time of filing charge sheet, his name was not mentioned in the charge sheet by the Ayog. Hence, the learned additional PP has prayed for impleading Hemanga Thakuria as an accused in the instant case. During the course of hearing, learned counsel for the accused Dulal Chandra Das prayed for passing order as per law. Also heard learned additional PP. I have perused the evidence of PW1 Ramesh Chandra Das, who was examined on 5/7/2024. A vital part of his evidence reveals that one Hemanga Thakuria also assaulted him by giving blows on his face and chest. PW1 stated that the blow had fallen on his lip and injured his lip. He also stated that Hemanga Thakuria and Jinti Das gave him blows on his ear. I have perused the case report. It appears that there are incriminating materials under section 23 of IPC against Hemanga Thakuria and Jinti Das, accordingly cognizance under section 223 of IPC.
Where is the FIR?
FIR at page number 14, my lord. In the FIR, my lord, Jinti Das.
Let us read.
My lord. With due respect, I beg to inform you that today on 28/7/21 at about 10 a.m. in the morning, while I was going to market from my house, the accused persons restrained me in front of my house and have assaulted me by putting me on the ground and have blows and kicks upon me. Hearing my hue and cry, my daughter-in-laws, namely Moromi Das and Anita Das, had rescued me from the accused persons and made me to sit in the veranda of my house. After some time, the aggressive accused persons again came to my house to assault me. After seeing the closed grill of my house, the accused persons thrown stones toward me from the gap of grill. The stones thrown by accused persons toward me have hit my head, hand, leg, chest, etc., and caused grievous injury. Now, my lord, kindly see the.
I have seen Jinti Das was not there.
My lord. Jinti Das.
But Hemanta was mentioned.
Yes, he was mentioned, but not charged sheet.
So that can be, PP can have that and the court can exercise the jurisdiction.
Yes, yes.
But so far as, yes, Mr. What about Jinti? Come to page 18.
Yes.
He was not so seriously injured that he could not name.
Yes.
He lost consciousness at the incident. Dulal Himangshu
Hemanta
mentioned as accused.
Yes.
Charge sheet was submitted,
Yes.
right?
Yes.
Against only Dulal.
Dulal.
Page 20, not
Yes.
sent up.
Yes.
Hemanta. According to IO, it
Yes.
should be, she should not face the trial.
Yes.
But Dulal, Ramesh, informant, page 23.
Yes.
He again mentioned, I lost the case against Hemanta,
Hemanta.
right?
Yes. Yes.
So let us see Hemanta's involvement,
My
page
lord.
23.
Page number 23, my lord. PW1. I am the informant of this case. Exhibit 1. PW1 is the FR and exhibit PW11. PW1 is my signature. I lost the case against Hemanta Thakuria, Dulal Chandra Das, and Himangshu Das. The incident took place on 28/7/21 at around 9:30 to 10 a.m. morning. Earlier, Hemanta Thakuria had rebuked my elder son. I am LLB pass, so do not utter anything in my presence. On the other day, I was proceeding from my house towards Palasbari Bazaar. I saw Hemanta Thakuria on the way. I asked him as to why he had rebuked my elder son. When I asked Hemanta Thakuria, he gave a blow on my face. The blow had fallen on my lip and injured my lip. He also kicked me on my chest. The accused persons, Hemanta Thakuria and Jinti Das, have gave me blows on my ear. A few laborers were clearing the roadside jungles on the road. They shouted, Morileo, Morileo. My daughter-in-law, Moromi Das, and my sister-in-law, Anita Das, came and took me to my house. Thereafter, Himanshu Das, one of the accused, called another accused Dulal Das, and both of them went to my house to assault me, but my daughter-in-law locked the grill of our house. Dulal Das threw 3 stones from outside the grill. One of the stones injured my gum and my teeth was broken. Another stone injured my forehead. At about 11:30, I went to PS and lodged the FIR. Police took me for medical examination. I was forwarded to Azra PSC to GMCH. I was also examined at GMCH and given treatment. I can recognize the accused persons Dulal Das and Hemanto Thakuria who are present before the court.
Yes.
During
My lord, yes, my lord.
Hemant
As per PW1, my lord. Hemanto's name is specific.
Zinti again brought in, but in the FIR, that informant, he
Yes.
did not implicate Zinti as an accused.
Yes,
How
ma'am.
can he bring sin?
And also, Lordship, may
Zinti
kindly
Das.
page 24, last part, my lord, cross, my lord.
24.
Page 24.
Yes.
Last part of the cross, my lord.
Yes.
It is a fact that I did not state before the IO that when I asked Hemanto Thakur, he gave a blow on my face and blow had fallen on my lip.
admitted the next one.
What is the standard required for accessing power under 319?
Yes, ma'am. First of all, my lord, it has to be more than prima facie case, my lord. And the evidence which is on record, my lord, if goes unrebutted, ma'am, it will lead to conviction, ma'am. And the record says, my lord, there is proof contradiction, ma'am. Yes, for the first time he has stated before the, during his deposition, my lord, he has stated new things, my lord.
No, Hemanto is there.
Yes, Hemanto is there, my lord, but contradiction is there regarding.
Oh, that is a matter of appreciation, but in the chief, he has implicated Hemanto.
Yes,
And in the affair also, he implicated Hemanto.
Why, my lord? Because
And
there is
161, that is a contradiction, that is to be appreciated.
yes, my lord. Before issuing summon, my lord, before taking cognizance, it has to be appreciated.
Do you have the judgment of Hardeep Singh?
Yes, my lord. I am relying on that judgment.
Let us have a copy. Which is the relevant paragraph?
My lord, I am relying on my paragraph number, my lord. 105,
105.
my lord. I have taken mark it at page number 29. Hundred and 105 and 106. my lord. Next, my lord. 17.5, 117.5 is number 32.
But in page 25, again, my lord, lordship may see the first line. Cross part, my lord. Yes, suppose.
It should be stayed.
But lordship.
This order should be stayed.
Yes, only thing.
Cross-examination.
Yes, again, my lord.
There is nothing,
And
no
page 20.
discussion. Why incriminating materials? On
Page
the
20
standard which
yes.
has been laid down in Hardeep Singh.
Yes.
It is not privacy case.
Yes.
It is much more
Much
than that.
more, yes,
Standard
if
is
it is not.
required. I think Mr. Kyle would be agreeable because me and Kyle, right? In that CBI case,
Yes.
319 on the basis of Hardeep Singh. Much higher standard is
Yes.
required to someone. Hard.
Page, have your lordship, perhaps your lordship has seen page 25, your lordship.
I have seen page,
Yes.
I have marked
20, it is not,
the cross-examination part.
yes, it is not a fact that I did not state before. that.
Clearly contradiction has been brought out.
Yes, two seconds.
Even previous statement is not required to be resorted. He
Yes.
admitted.
Yes.
He admitted.
Again, my lord,
Not
this-
required. Contradiction is brought out.
Brought out.
Regarding Hemanto,
Lords.
Zinti,
Lords.
name for the first time.
Lords.
By testimony, you can rope in everybody, no? Hard, Mr.
H. Ali. H. Ali.
H.
Ali.
Ali, Learned Counsel for the Petitioners, and Mr. MP Goswami, Learned Additional Public Prosecutor, for the respondent, number 1, State of Assam, full stop, in this criminal petition, a challenge is made to an order dated 13/11/2024, passed by the Court of Learned Chief Judicial Magistrate Kamrup Metro in PRC case number 944/2022. Full stop. By the order dated trial court 13/11/2024, Commander Learned Trial Court, in exercise of the powers conferred under section 319 CRPC. What is the equivalent provision now?
My lord,
Please. Now it will be, I think, BNS.
Yes.
T50S, within bracket. Presently, section 358 BNS S লিখে দিব। The Learned Trial Court has taken cognizance for the offense under section 323 IPC against the two petitioners, stating that there are incriminating materials revealed from the testimony of PW1 press informant during his examination on 5/7/2024. Full stop. Para, the matter would require further consideration. Issue notice returnable, 4 weeks. Returnable on corridor. As Mr. Goswami appeared accepted, options of formalities dispensary. The petitioner shall take steps for service on this. On the response number 2 by registered post with date the post of para. To exercise the power under Section 319 CRPC. It is settled that though only a privacy case is to be established from the evidence laid before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of the person's complicity. The test has to be applied is one which is more than privacy case, as exercised at the time of framing of charge, but sort of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. Full stop. The name of the petition, the petitioner, sorry, the informant, that's PW1, lodged the FIR, stating that he was assaulted on an incident which occurred on 28/7/2021. Full stop. The charge sheet was submitted for the offenses under, sorry, charge was framed under?
Charge under, my lord, against Dulal, my lord.
No.
Against him,
The charge sheet was submitted only against one Dulal Chandra Das. The offense under
294 and 323.
323 IPC. Full stop. Thereafter, comma. Charge was framed when? Charge was framed under?
Under 294, 323 and 34.
294 stroke?
34.
323?
And 34, my lord.
34?
My lord, one Himanshu Das was also there primarily, my lord. He was declared as juvenile.
Okay. 34. Against the against two succeeded accused persons, Dulal Chandra Das and Himanshu Das, within bracket later on declared as sent to the juvenile court under section so and so. The informant PW1 did not name the petition number 2 in the FIR and had named her only during his testimony as PW1. On the other hand, comma, though Himanshu, the name of the petitioner was mentioned in the FIR, comma, the informant as PW1 during his testimony had admitted to certain, admitted to the extent that he did not state the name of petition number 1 during his statement, previous statement. First of having regard to the above, comma, the operation of the impugn order dated so and so.
13/11/20.
Passed under section 319 CRPC by the trial court shall remain suspended till the returnable date.
5th September.
And the
5/9.
because scan copies, because 161 statement is to be perused.
Yes.
Problem.
Item 13.
Please, your lordship. Versus this application against order dated 29/5/25 passed by the sub-divisional judicial magistrate lordship, thereby rejecting the interim maintenance.
page?
Lordship, page number is,
Page?
lordship, page
Bit
number
louder, madam.
68, lordship. Lordship. Page number 68, lordship. Page number 68, lordship. May I read the order, lordship?
Well, you should notice that this is hard Miss M. Nirola, learned counsel for the petitioner. Aggrieved by rejection of our prayer for interim maintenance by an order dated 29/5/2025, passed in Miss case number 20/2024 by the Court of Learned Subdivisional Judicial Magistrate M. Vishwanath at Vishwanath Sareli. The petitioner has approached this court by the instant criminal petition. Issue notice returnable in 4 weeks. The petitioner shall take state for service of notice upon the respondent by registered post AD as well as by usual process within 2 working days from today.
Item 14.
May I please, your lordship? Your lordship, we did not receive the report as the IO was on leave. So your lordship may grant us further time to obtain the
How much
instruction.
time?
Your lordship, after 22nd August.
22nd. Yes, madam.
Lordship, my senior is in lax, lordship. Madam.
Where is Mr. Cal?
Your lordship, he is on legs in court number 16.
Okay. Okay, when they are available, we may suspend also the order, impugn order. Okay, let him be there. Yes, Mr. Jain. We may suspend the order also.
1 week may be done. Till that date, your lordship. 1 week.
1 week.
1 week.
Where is Mr. Biswas?
He is on another court, lordship.
Okay,
He's in
let them come.
Item 16.
May it please, your lordship.
Yes.
This is a criminal petition under.
Which
section-
order you have challenged?
I have challenging the order, Annexer 4, lordship, page
Annexer 4,
30.
page,
Page 30.
page
Page 30.
30.
Married. I have gone through the record. It reveals from the case record that several steps were taken against the accused person. The report of non-valuable warrant of arrest issued against the accused person returned with a report that the accused person is not found in the given address.
Let
and-
us find the previous order.
Yes.
Now, what is the, let us see,
Lordship,
the FIR first.
FIR,
Momota
page, Lordship,
Balaram Mondol.
14.
Page 24, lordship.
Page 14.
24, lordship, previous
Understood.
orders.
No, FIR.
FIR 14.
14, ma'am.
14.
Momota Balaram.
Translated version.
Nomina. Balaram Mondol is the husband of the informant.
Yes.
So it is 498A
Yes.
and
And
494.
494.
CI plus CI plus. Then search it.
Search sheet. In the search sheet,
The second wife was not sent up. Accused was sent up.
yes.
Privacy case 498A, 494. Then search is submitted, then privacy accused person summons issued duly served. Someone was served.
Someone was served, but someone was not received by the accused person because he was out of station for his livelihood, out of his state.
Petition
location.
by the petition father. He has no communication with his son. NWA.
Lordship, someone received by his father, petitioner's father.
So that is due service.
Petitioner's, but not.
Due service, is it not, as per the CRPC?
Yes, but he informed before the honorable court by filing a petition, and that is the order.
Someone house served. So
Yeah.
served.
Lordship, that is the order passed by
Someone
the
to corporate body, someone cannot.
Learned Trial Court, page 11, page
Sir,
21.
Some adult member. Then NBWA issued.
Yes, Lordship.
NBWA issue.
Order dated 19/8/2023. Page number 21.
2023, NBWA issued.
Yes.
Then subsequent orders.
Subsequent orders passed,
Issued.
issuing non-available warrant of
Put
arrest.
up your trial magistrate and absent. Someone is duly served. Hard. Yes, sir, Goswami.
Lordship,
Old 80s, old CRBC section
Yes.
82.
section 64, Lordship.
Now 64.
Earlier 64, my lord. Now, my lord, it will be.
64.
Yes.
There is a condition that by leaving one of the duplicates for him
Yes.
with some adult male member
No.
of his family
Yes.
residing with him,
BNS 66, man.
PNS 66.
66. And also regarding procedure, my lord, but it as per 62.
66.
Yes,
Now
63.
question is residing with him. Now, he left the home more than 1.5 years ago.
Yes, that is the.
So residing with him, his condition is
Yes.
not fulfilled.
Not full.
That is one.
Yes, ma'am.
Secondly, come to BNSS 84. Subsection 4.
No, sir.
498 is punishable by what?
3 years.
7 years, madam. Up to 7 years.
Up to 7 years or 3 years?
No.
3 years.
Yes,
498.
3 years. 498, 3 years.
494, that is 7.
490. Because our order should not suffer from infirmity. That is why I am looking at it, otherwise not. 494. Let us see.
98.
Meeting again
490.
during lifetime is 7 years. 494.
Yes, 7 years.
And 498A,
3 years.
3 years. Now see subsection 4 of section 84.
Lordship.
Do you have the BNSS?
Yes, Lordship. Is in respect of a person accused of which is made punishable 10 years or more.
With imprisonment of 10 years or more.
10 years or more.
Or imprisonment for life.
Life.
Or with death.
Or with death.
Under B and S.
S.
Or under any law.
Nice.
And such persons fails to appear at the specified place and time required by the proclamation.
Yes.
A court may, after making such inquiry as it thinks it, pronounce him a proclaimed offender. Make a declaration to that effect. Have you understood what I am pointing?
Yes, because here, my lord.
By the Tribune
But
order, he has been declared as a proclaimed offender.
But it
But
is 3
he
years.
cannot be declared as a proclaimed offender.
It's 3 years, my lord. because
3 years and 7 years.
7 years.
That is one flaw
No.
in this order.
No.
6/11/2024.
No.
Right?
No.
Proclamation can be issued,
Issued, my lord.
but cannot be declared as a proclaimed offender.
No. As per this.
That is the interesting part.
Well,
We
Yeah.
normally keep
Yeah.
our eyes closed.
Yes, yes.
Then secondly, first condition,
Yes. Another thing that
19.8, residing with him.
residing part.
There is a clear statement,
Lordship.
page 24.
Lordship, I have one. 1 year, 8 months is there. Not
But condition is residing with him.
Lordship.
Without ascertaining that you cannot.
Yes. Yes. 2 flaws are there.
So you are ready and willing.
Lordships,
Would you appear or not?
yes.
I can copy to the so and so. This is the order only, page 30.
Yes.
Yes, only my digital.
এই ইন্দ্ৰৰ এই এটা যে এই তাতে আছে ৱাৰেণ্টৰ এটা দিয়া আছিল নহয় এটা ইয়াৰ আগতো দিয়া আছিল ন that 611 should be set aside.
Yes.
Page 30. Is it not?
Yes, as per the my lord 84-4 if we
84.
No.
Similarly,
the other part.
CRPC, same
Yep, same.
provision. CRPC, it was specifically mentioned as that the provisions are mentioned. See,
No.
section 88 perhaps, 80, 82.
Yes, Lords 80.
See the offenses.
82 my lord.
See the offenses.
Lords.
Would you appear? When?
Yes, Lordship.
When?
10 days may be given.
Huh?
10 days may be given.
10 days.
Yes.
Okay, I am giving you 2 weeks. Today is what?
To the 4.
Today is
4.
11.
4 August.
So 4.
4 August.
Okay. Before 20. Before 31st August. You appear?
Yes, Lordship.
Yes, anything?
No,
Whether my
Yes.
view is wrong?
no, my lord, because
No, please.
as, no, as per the, my lord, if we go by the 84-4, my lord, very specific, my lord.
Very specific.
But
So this cannot be, he cannot be declared as proclaimed.
10 years or more.
And secondly, the condition is
Residing, my lord.
residing with him.
Yes, my lord, that,
So there is a clear statement.
lord,
So without ascertaining, NBW should not be have been issued.
yes, if he is not, cannot be, my lord.
Will not make full observation,
Lots of-
just give a tentative observation.
Lordship, he will appear.
But this proclaim offender declaration is to be set aside.
Say this.
And we can make it convert to bailable warrant of arrest.
Yes. But without my lord setting aside whether it can be done.
No, the NBW order.
Oh, NBW order, yes.
Okay, we'll set it aside.
Yes, and with NBW order.
Heart, Mr. A.L. Mondal. Learned counsel for the petitioner. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent state. Full stop. Para. Before. Any dilation on the impugn orders, comma, it is opposite to state the background facts, comma, in brief, comma, at first, full stop. The petitioner. Sorry, the informant. Of one, Srimati Mamta, M-A-M-T-A, Mondal, was the informant in the first information report lodged before the officer in charge, Mayang Police Station, on 5/12/2021 in connection with Mayang Police Station case number 2270/2021, registered under sections 498A/494/34, comma, Indian Penal Code. Full stop. In the FIR, comma, the petitioner herein was named as accused number 1 and 1. Srimati Sharmila Mondal was named as accused number 2. Full stop. It was inter alia alleged that in an incident occurred on 31/10/2021, comma, both the accused persons assaulted the informant and drove her and her younger son, comma, aged about 6 years, comma, out of her matrimonial son house. Full stop. Para. After investigation, comma, the IO of the case submitted a charge sheet by charge sheet number 167/2021 on 26/12/2021, wherein the petitioner has been charged sheeted had been solicited as petitioner was only charge sheeted, finding a sufficient materials against him to stand in the trial for the offenses under section 498A and 494, section 494 of the IPC. First of the other accused person, similarly Sharmila Mondal, named in the affair, was not charge sheeted. Full stop. Upon submission of the charge sheet, the case was registered as PRC case number 233/2022. Full stop. When the case records of PRC case number 233/2022 was put up before the Court of Learned Subdivisional Judicial Magistrate of S. Morigaon on 19/8/2023, the accused petitioner was found absent. First up, the Learned Trial Court recorded that the summons issued to the accused petitioner had returned after due service. First up, on that day, that is on 19/8/2023, a petition petition number 2905/2023 was filed by the father of the accused petitioner, namely, Sri Dhiren Mondal, stating that he had no communication with the accused petitioner, son, for last about 1 year and 8 months. Full stop. The Learned Trial Court, having considered the same, proceeded to issue non-bailable warrant of arrest against the accused petitioner. Full stop. On subsequent dates, date here likhi dibo, page 21 or date kita ase. The Learned Trial Court, finding a recording absence of the accused petitioner with the steps, ordered for issuance of fresh non-bailable warrants of arrest against the petitioner. Post up. When the case was posted on 6/11/2024, the Learned Trial Court had passed the following order, page 30. Mr. Mondal, Learned Counsel, preparing for the accused petition, has submitted that the accused petition is a daily laborer, and for source of his in order to earn livelihood, he started residing outside Assam. Full stop. He has further submitted that the statement made by the father of the accused petitioner by petition number 2905/2023 before the Learned Trial Court on 19/8/2023 was correct. Full stop. He has further contended that in view of such in the above backdrop, the issuance of non-bailable warrants of arrest, by the orders under reference was not proper on the part of the Learned Trial Court. So he has further submitted that the accused petitioner is accused for committing the offenses under section 494 IPC and section 98A IPC. And for such offenses, comma, the accused petitioner could not have been declared as a proclaim offender. Full stop. Mr. Usami, Learned Additional Public Prosecutor appearing for the state, has submitted that there is no infirmity in the order dated 19/8/2023, as the summons issued to the accused petitioner had returned after due service. Full stop. Para, as per the provisions. Now, section 64 of the Code of Criminal Procedures 1973, CRPC. Stroke. Section 66 of the Bharatiya Nagarik Surakha Sanhita 2023 BNSS has provided for service of summons when persons summoned cannot be found. Post stop. It has been provided that where the person summoned cannot, comma, by the exercise of due diligence, comma, be found, comma, the summons may be served by leaving one of the duplicates for him with one adult male member, stroke, with some adult male member, stroke, adult member of his family residing with him, comma, and a person with whom the summons is so left, comma, cell, comma, if so required by the serving officer, comma, sign a receipt therefore on the back of the other duplicate. Full stop. From the aforestated provision, comma, it could emerge that in the event the person summoned cannot be found despite exercise of due diligence, comma, the summons may be served by leaving one of the duplicates for him with some adult male member, stroke, adult member of his family residing with him. Full stop. In the case in hand, comma, the first condition of serving the summons upon one adult male member, stroke, adult member of the petitioner's family is found to be fulfilled. Full stop. It is the father of the petitioner upon whom the summons was served had approached the learned trial court by petition number so and so 2905/2023, stating that he had no communication with his son, stroke, that is the accused petitioner, for a period of last 1 year and 8 months. Full stop. In view of such statement before the court, comma, it cannot be said that the second condition, second requirement, that the adult member, stroke, adult member of the petitioner's family has been residing with the accused petitioner at the time when the summons were found to be served. Full stop. There appears to be no effort to assert it on the part of the learned trial court to ascertain as to whether the accused petitioner at the relevant point of time was residing with the father or with his father, and there is No. So there is, Loretta trial court did not record any finding on the, to contrary to the statement made by the father of the accused petitioner in petition number so and so. Full stop. Para. The Section 82 CRPC stroke Section
84.
84
Yeah, BNSS.
BNSS has provided for proclamation for person absconding. The provisions of subsection 4 of section 80 and subsection 4 of section 84, BNSS
84.
have provided the Honorable Court Corridor. Para IPC. The petitioner is likely to face charges under section 494 IPC and section 498A IPC in the proceedings of PRC case number so and so. Full stop. If a person is found guilty of the offense under section 494 IPC, comma, the convict can be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Full stop. A person held guilty of the offense under section 498A, comma, can be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Full stop. Para. In view of, in the context of the provisions contained in so and so, 80 CRPC stroke 84 BNSS, comma, the petitioner, his petitioner who is likely to face the charges under so and so could not have been declared as a proclaimed offender. Full stop. Para.
Eighty-four-4 is a exclusive section, my lord. It is an exclusive section regarding, my lord, 10 years and imprisonment, my lord. And my lord, it is not clear, my lord, from 1 and section 2 and 3, my lord, if anybody don't appear when punishment is less, my lord.
No, I am saying
And
he cannot
it
be
is not
declared proclaimed offender.
Yes, ma'am.
Proclamation can be issued.
Issued, my lord.
The difference is that
Yes, my lord.
proclamation can be issued,
Issued, my lord.
right?
Yes, my lord.
One, say subsection 1 and 2 can be done,
Done, my lord.
but
Yes.
4 cannot be done.
Well, my-
But see the order.
And yes, ma'am, that is it. No, no, just my, for the purpose of my, if my lord, they don't appear as per 1 and 2, my lord, that part is not missing.
Proclamation and attachment can be done.
Done, my lord. But cannot be.
Proclamation and subsequently attachment.
Attachment.
But he cannot be declared as proclaimed offender.
Yes, if, yes, that part is separate
So
explicit.
this is clear.
Yes, clear.
Ms.
my lord.
30. I am
Yes.
only interfering with that
Yes.
without any discussion on subsection 1
Yes,
and 2.
Yes, yes, my lord.
Because that was not done.
Yet not done, my.
That part was not done even
Not done.
by the court.
Yeah, even
not
for,
go into that.
yes, even for 4 also, 2, 3 has to be satisfied, my lord.
Dude, that is not satisfied.
Yeah.
I am not into, I am not discussing it.
Lordship, yes,
That was not done.
not done.
But at least subsection Or say he has reason to believe.
Reason.
He
Yes.
has reason to believe
Yes.
somewhere it is there.
After making such inquiry, as it thinks fit, pronounce him.
We'll add that without there was no adherence to the procedure
Yes.
of subsection 1 and 2.
1 and 2 also,
We'll
madam.
record it. লিখি দেবো খালি। Para. In এইটো চাই ল'বচোন SCC in so and so Raghuvansh. The Honorable Supreme Court has observed as under para 9. তাৰপিছত para 10 টো কোট কৰি দিওঁ। Para since execution of a non-bailable warrant has a direct has impinges upon the right to life and personal liberty of a person enshrined in Article 21 and 22(1) of the Constitution of India. They need to be strictly complied with. In the light of the discussion made above, there is the order dated 19/8/2023 and all subsequent orders whereby the trial court had issued non-bailable warrants of arrest against the petition is found unsustainable in law, cannot stand the scrutiny of law. Post of similarly, the order dated 6/11/2024, whereby the accused petitioner has been declared as a proclaimed offender, is found unsustainable in law. Post of, as a result, both the orders, all the orders are liable to be set aside. So it is accordingly ordered. So, para the petitioner has submitted that he is ready and willing. বাকিখিনি লিখি দিব NBW যে লিখা যায় যে সাসপেন্ড কৰিব নালাগে, ইয়াতে সাসপেন্ড কৰিব নালাগে on or before 31/8/2025. Yes. In response to the summons issued to him in connection with PRC case number so and so before the learned trial court on his appearance so and so, that his application will be considered for in accordance with law. But you appear without default.
Yes.
For expeditious conclusion of trial. Yes, Mr. Kyle and Mr. Biswas.
14.
When do you want?
Here, I was directed to obtain instruction. Lordship,
Regarding stay and stay.
No, nothing. No, Lordship, here, prayer of the petition may be allowed. Because he's asking for recall of the provision order. He and attacking that he will appear before the authority. In the case, Lordship is pleased to see the last line of the order dated 28/10/2024. Page 54.
Page 54. Now, firstly,
In 14.
28/10.
firstly 53.
53. NVW issue against the accused Kasturi Prasad Shukla returned unexecuted.
Hmm.
Issue phrase
In
NVW.
that case, without recording any reason to believe that he is an absconder, how can the court issue this NBWA
No, Lordship,
and
he-
proclamation?
Lord-
And thereafter, immediately on the next day, how can the court declare? I'm
Probably,
not into
probably not on the next date, Lordship. In between, there are many order were
maybe
passed.
8/8/2024, maybe two,
Yes.
three order. But if the original order
On that day, I have given.
suffers,
No, Lordship, I'm not on that. Lordship, his prayer may
I
be
am
allowed.
also in the interest of an expeditious trial.
Lordship. Lordship, in
But
this case,
the question I wanted to know, actually, I am firm in my view.
Lordship.
That is not going to be changed. This order cannot sustain 8/8/2024. If it does not sustain, the next order does not sustain. Right? But I am only to record the view that whether there was stay of the
Lordship, before Supreme
proceedings.
Court, there was no stay.
Huh?
Before Supreme Court, there was no stay.
No
That I take up from the registry of the Honorable Supreme Court. There was no stay.
And secondly, was there the case was posted in the trial court?
Yes, Lordship. Lordship, may please to see.
Mr. Biswas should be knowing better.
I know, I have talked to you.
Yes.
Now it
whether-
has been again restarted.
In,
by-
before the High Court?
High Court before it was allowed, our petition
No, no,
was allowed.
stay was there or not there?
High Court has set aside the order.
Please
Initially, stay was there.
stay was there. Don't say, I need record, Mr. Biswas. Falling from a counsel's mouth will not suffice. Where is
Lordship,
the order?
Lordship, probably everything will be clear by page 51, Lordship.
No, High Court's order.
Page 51, Lordship.
High Court is,
You have read the brief many times, that is why.
High Court order is 32 onwards, man.
Where is the last part?
Last part is
Page 46.
yes. Para 21.
There is no mention about staying.
Lordship, probably order dated 3/7/24 passed by the London Trial Court will
Huh?
be order dated 3/7/24 at page 50 will clarify the entire position, Lordship.
Okay, we'll pass the order tomorrow.
No. Lordship, only
That is morning.
my submission before Lordship, that he may be allowed to execute fresh bail.
Yes.
Because Lordship earlier bailer.
He will appear.
I will appear.
He will appear because he will appear in terms of the order dated 3/7/2024, page 51.
And he will he will go execute the fresh bail bond. Much of it.
Tomorrow 10:30.
What's
Hey, Raghuvanshi to ready to teach you. Yes. Please the case tomorrow.
Item 17. May it please your lordship. I am seeking reduction in a bail amount imposed by the learned session judge Morigaon. Page number 23 is the impugned order.
Yes.
Chip will have paragraph 4. If I may read.
Where is the scheme?
Lordship, the scheme is at page 28.
Yes, Mr. Goswami.
Lordship.
Do you implement this?
This portion, man, I.
Are you implementing this or not?
My lord.
Money is
I-
going back to the central government
Lordship.
if you are not implementing it. Heard, Mr.
A. Atreya.
A. Atreya. Government advocate.
Women, because
Call
someone.
Learned counsel for the petition. Mr. MP Goswami. Learned additional public prosecutor for the respondent number 1, State of Assam. And Mr. Suenso. Learned State Council for the respondent number 2. Full stop. The petitioner is standing in the trial of sessions case number 54/2024 before the learned sessions, before the court of learned, before the court of sessions,
Yeah.
Morigaon, as the sole accused.
Lordship, sole accused.
Sole accused.
Sole accused.
Full stop. Subsequent to investigation. Subsequent to investigation carried out in connection with Morigaon Police Station case number 24/2023. Registered under sections 326 and section 307 of the IPC, a charge sheet by charge sheet number 67/2024 was submitted by the IO of the said case on 31/3/2024. Finding sufficient material against the petitioner to proceed for the charge of murder under section 302 IPC. Full stop. During the course of investigation, the petitioner was arrested on 12/10/2023.
Lordship, there is a error in the date of arrest. It is 12/12/23.
12/12/2023. And since then, the petitioner is in incarceration, full stop, after framing of charge under section 302 IPC by the Learned Court of Sessions against the petitioner. The petitioner is facing the trial as an under trial prisoner. Full stop. During the course of the trial, which was which is at the stage of, which was at the stage of recording evidence, comma, an application was moved. Oh no. Para. It is stated that during the course of investigation, comma, an application was moved on behalf of the petition for bail under a default clause. And by an order dated 22/03/2024, comma, the petition was allowed default bail. Full stop. During the course of the trial, comma, an application, a petition, petition number, page 23, 765/2025, was moved before the learned Court of Sessions for bail of the petitioner. Full stop. The learned Court of Sessions, considering the fact that the petitioner is inside the jail undergoing incarceration for more than 1 year, comma, has allowed the petitioner to go on bail or rupees 20,000 with a security of the like amount, with the condition that the petitioner shall appear before the court regularly and shall not in any way give threat or coerce any witnesses acquainted with the facts and circumstances of the case. Page 23. Para. As despite the order dated 31/3/2025, 13/3/2025. The 13/3 or 03?
03/03.
Yeah. The petitioner is still in jail. Para.
Scheme it up.
The petitioner has asserted that he is an indigent person and comes from a poor economic background. Full stop. The family of the petitioner is unable to furnish any security to the extent of rupees 20,000 in absence of any immovable property in the family. Full stop. The petitioner's family is unable to furnish bail of even 20,000 either in case or in the shape of any, in the form of any solvent bailor, the satisfaction of the trial court. Full stop. As on date, comma, the petitioner or period of incarceration is more than 657 days since the date of his initial arrest. Full stop. Para. The petitioner has referred to.
Lordship, it will be 601 days, Lordship. There is an error in the date.
As on date.
As on
601.
601.
As on date.
As on date.
Okay, as on date, 601. Has referred to the provisions of the scheme named support, quote unquote, support to poor prisoners for providing relief to poor prisoners, comma, who are unable to, framed by the government of India. Full stop. The scheme is meant for the poor prisoners who are unable to pay the fine imposed on them or unable to secure bail due to financial constraints. Full stop. The scheme was launched in May 2023 with the objective of providing financial assistance to states stroke union territories for extending relief to poor prisoners who are unable to secure bail or release from prison due to non-payment of fine on account of financial constraints. Full stop. A detailed set of guidelines and a standard operating procedure for implementation of the scheme were issued to all states and union territories on 19/6/2023. Full stop. Para. The guidelines and the standard operating procedure has provided for a central nodal agency and an empowered committee in each of the districts of the states and stroke union territories. Full stop. An empowered committee is to be constituted in each district comprising of page 35 comprising of 5জন মানুহৰ নাম আছে। It will give you page 35. The standard operating procedure for under trial prisoners are laid down as under. Page 35. 35, 36. It is an obligation is cast upon the secretary, district legal service authority to place all such cases before the all cases where the under trial prisoner is not in a position to furnish financial security for securing bail in terms of the bail conditions before the district level empowered committee every 2-3 weeks. So after examination of such cases, if the empowered committee recommends that the identified poor prisoner be extended the benefit of financial benefit under quote unquote support to poor prisoner scheme, then the requisite amount up to rupees 40,000 per case for one prisoner can be drawn and made available to the honorable court, to the concerned court by way of fixed deposit or any other method, which the district committee feels appropriate. Full stop. It has from the office letter dated 3/1/2024 of the Government of India Ministry of Home Affairs and addressed to the chief secretaries of all states, June 2002, June 3, 2025, it can be noticed that funds have been made available by the Ministry of Home Affairs in the Central Nodal Agency account, from where appropriate amounts can be drawn by the states stroke union territories for providing benefit to eligible prisoners. It is further mentioned that despite repeated follow-up, funds have remained unutilized as many states stroke union territories have not identified eligible prisoners and have not provided the benefit of the scheme to them. As the petitioner is in need of the benefits under the scheme support to poor prisoner scheme, and the amount of surety is within the limit of 40,000, the State Council shall obtain specific instructions from the Secretary, District Legal Service Authority, Morigaon, whether the case of the petitioner has been placed before the District Empowered Committee Full stop. And if so, please come on the outcome. The decision taken there. A copy of this order is to be furnished to Mr. Pegu for taking necessary, for obtaining necessary instructions in the case. Full stop. Please the case on 18. Get it done. I am not asking for instruction. I am implicitly observing that get it done.
Item 20.
There is no representation on behalf of the petitioner to the uncalled.
20.
Mr. R. Kosing, post-petitional public secretary is in attendance. In view of such representation, let the case come up for of justice, be listed. After a week.
21.
May I please, Lordship?
Yes, sir.
Lordship, in this case, Lordship, the learned court below has issued a distress warrant on the 9/3/2021. Kindly page number 39, Lordship, Annexure 8. But Lordship,
Annexure?
Annexure 8, Lordship.
8, page.
Page 39, Lordship. And the Lordship, this the distress warrant was issued. Thereafter, Lordship, the warrant could not be executed.
Why?
Actually, Lordship,
The situation has reached such a stage.
Lordship, this is maintenance case, Lordship, and the judgment was passed on the 7th.
Judgment, when judgment was passed?
7/6/2018, Lordship.
7/6.
Yes, Lordship. 7/6/2018, Annexure 2, Lordship.
Deepanjali Panika, Ruhit
Case number
Panika.
21.
What is the operative part?
Lordship, in that judgment, Lordship, the respondent was.
Willfully neglected. So this willful negligence has continued.
Yes, Lordship.
Willfully neglected, the petitioner may refuse to maintain. So 4,000
Yes, Lordship.
per month, 7/6/2018.
Yes, Lordship.
Did you prefer any revision against it?
Then, Lordship, I paid some amount, Lordship.
No. Did you prefer any revision against it?
No, Lordship.
Seeking modification?
No, Lordship.
So that has attained finality.
Yes, Lordship.
So 4,000 means 48,000 per year,
Yes, Lordship.
right?
Now, Lordship, that year
2018,
amount.
how
is-
much?
Yes.
How many years?
Lordship,
How many years?
Lordship, more than 4 years, Lordship.
4.
Yes.
2008. What is the order? Judgment is 2018.
Yes, Lordship.
7 years.
Yes, Lordship, 7 years.
Say 50,000
Yes.
into 7.
Lordship, that
3,50,000.
Yes, Lordship.
How much you paid?
Lordship, I paid 32,000, Lordship.
Only.
Yes, Lordship.
Not even 10%.
Yes, Lordship.
So let you be taken into custody.
Lordship,
That will be the best
yes, Lordship. But
possible way out.
Yes. But Lordship, the SOCOS notice was issued to me, and that notice was not a served, Lordship. The SOCOS notice was issued.
Itself order.
Yes, Lordship, I agree, Lordship.
Not adhering to the judgment itself is willful.
Yes.
Prior to that also,
Yes, Lordship, I agree.
the
Lordship.
judgment observed. Willful negligence.
Yes, Lordship, I did not appear.
Right.
Lordship. And that the matter proceeded ex parte, Lordship.
And in spite of having sufficient means to do so.
Lordship, I having not a sufficient means, Lordship, in the complaint petition, Lordship, the petition, the respondent stated that I am a driver. And the Lordship, in that judgment.
Driver will become the owner also, I don't know.
No, Lordship.
Owner of the fleet of vehicles.
And the Lordship, the triangle also
Notice to
observed.
be absent, notice issued, not return, issue. Esterpo petitioner takes steps. And with served on. OP was served on so and so. And the opposite way as well is. Issue DW. Since 2018.
Yes, Lordship.
So what can we do?
Lordship, I appeared at the court, Lordship, 28/3/2019.
Where?
And I paid, Lordship, Annexure 5, Lordship.
Page?
Annexure 5, page number 34, Lordship. Lordship, in 2000.
3,000.
Then Lordship, I also paid the
3,000.
Lordship 9,000 Lordship in the 31st.
9,000, 12,000.
Then Lordship, I again paid Lordship 20,000 in the 7 to 2020.
12,000.
20,000 Lordship.
32,000
Yes, Lordship, total I paid 32,000.
in 2020.
Yes, Lordship.
5 years.
Yes, Lordship.
No way.
But Lordship, the NBW
Who
has been
can
issued, Lordship.
go to that extent? In 2022, it was area was 1,28,000,
Yes, Lordship.
right?
Yes, Lordship.
The limit of justice cannot be extended to such an extent.
Lordship, now.
Willful, every adjective is applicable for you.
Yes, Lordship.
No way, 3,50,000.
Now, Lordship, NBW has been issued, Lordship. If the Lordship, NBW suspend, Lordship, I will appear before the trial court and the Lordship, I will pay some amount of what I can pay, Lordship. But now,
No,
Lordship,
that kind of permission is not ever. I think it is to be realized by implementing the order. I think that it is there. Some observation was already made. That page 46. Page 46 order. Everything was served, so NBW, there is no illegality, no infirmity.
Lordship, the SOCOS notice was issued and the 16/3/2022, but Lordship, SOCOS notice was not served, Lordship. Since 2022, it was not served on me. And the Lordship, the learned court below has issued non-bailable warrant of arrest without a serving of notice on the 3/6/2024. Annexure
No report.
18, Lordship.
First, no report. By law. Your order is not complete.
Lordship, one page, Lordship, missing, Lordship. I want to submit a certified copy, Lordship. At the time of filing, it was not annexed.
Everything should be on record.
Yes, Lord.
You add that, we'll see that. But the main order, if it is not available,
Lordship, I want to, with the permission, Lordship, I want to submit a certified copy.
you complete the impugn order.
Yes, Lordship.
Mr.
Yes, Deuri.
As the Learned Counsel for the petition
Human.
has submitted
Taking.
that the copy of the impugn order dated 3/6/2025 is not complete. As how many pages?
Lordship, one page.
As one more page has not been annexed. The second page of the order is not annexed. So he has sought leave to annex the second page of the order dated 3/6/2025. So is the case on so and so date. Collector they give. In the meantime, Commander Mr. Deuri and Counsel for the petitioner is shall do the needful before the registry. Before the registry.
Yes, Lordship. Obviously.
13.8. Item 22.
I'm sorry, my lord, item number 20, which has been order has been passed, my lord. My lord, my presence may be shown, my lord. I was in court number
Prayer
16.
of Mr. So-and-so, is that yes on so-and-so.
Mr. A.K. Yadav. Obviously.
22.
May I please? May I please, Your Honor?
Yes.
Lordship, my senior counsel is busy in court number 10. Kindly please
Okay,
pass over the matter for time being.
not for today, Monday then.
Otherwise, this issue is similar to that PNA, that last order your lordship has passed, it's similar.
Okay. Friday then.
Friday.
Friday. On the prayer of Miss.
Yes, Chief.
Place the case on Swayam.
23.
May I please your lordship?
Hmm.
Lordship, I'm praying for quashing of a judicial order, which is on.
Passing of a judicial order.
Yes, your lordship,
Yeah.
attachment.
By the session judge.
Yes, your
Yes.
lordship. That is on page number 16, your lordship.
16, okay.
Lordship,
What kind of proceeding?
Pardon me, your lordship.
What kind of proceeding?
It is a criminal revision case. Lordship, what happened in this case is that, your lordship, I am in a possession of a piece of land, 2 bighas, since 1995 until 2024, and my name was mutated in 1997 in the Chitha register as per the due process, your lordship. But then
Now, what is the finding regarding possession?
finding, your lordship, without even hearing me, the judgment has been given in the favor of the opposite party, your lordship.
Original proceeding.
Yes, the original order, your lordship.
Where is the original proceeding?
First proceeding was before the ADM. Pardon me.
Where is the complaint has been lodged by the first party, supported by an affidavit?
Null-body, and then I preferred a
On which I on so and so in a have prohibited both the parties from entering
Hey, your lordship.
the further order. 2 days fixed for the second that is pen and whatever the original sale date for of the time and the go of science about the Article 19 order and drop the case. So drop the case. So drop the case.
Yes, yes, without hearing me, and he.
And then
Yes.
what did you do? You prepared the revision.
Yes, yes, your lordship. I made
And-
it before the.
Infirmity, illegality. Will issue notice at this stage.
Yes, your lord.
Alright, Miss.
Lordship issue and
PDAS,
PDAS, your lordship.
Land Council for the petitioner,
Lordship, interim may be considered, your lordship.
or returnable debt.
Yeah, yes, sir. Interim may be.
Returnable debt.
Yeah.
Challenging an order dated 25/10/2024 passed by the learned passed by the additional district magistrate in case number so page 15, which has been affirmed and a judgment dated 19/7/2025 passed by the Court of Learned Session Judge Nalbari in criminal revision case number 26/2024, page 16. As a revisional court, the petitioner has approached this court by the instant criminal petition prepared under section 528 BMSS. The petitioner has asserted that he is in possession of the disputed land, but both the courts below had erred in deciding the aspects against the petitioner. First of the learned, the additional district magistrate, this had decided decided the issue ex parte against the petitioner. Full stop. Issue notice returnable on so and so date.
3rd September.
The petitioner shall take steps for service of notice upon the respondent number, upon the respondents by registered posted AD as well as by usual process. The prayer for interim relief will be considered on the returnable date. The records of so and so case number called for. We are calling for the records.
Deeply obliged, your lordship.
24.
Yes.
My lord, this is a quashing petition, my lord. Originally, this is a case of civil nature. Lordship may kindly come to the first FIR.
Take me to the events first. FIR. then
FIR
what
page
happened?
number
What happened?
67, my lord.
Page
Page 67.
67.
67. This was the first FIR.
How many FIRs?
My lord, actually 3 FIR were lodged on a same cause of action, same date of occurrence, my lord. My lord, first FIR was lodged, my lord, 67. That was final report was submitted. After investigation, there is no materials
One
are found, my
minute.
lord. Page number 67.
67.
67. This is the
Secretary
translated
Dolgaon,
copy.
Ramesh, so
Yes.
you are who?
I am the in this FIR. I was the husband of the accused number petitioner.
No,
number.
there are two accused. Rameshwar and
No.
Salaur.
They are the informants, my lord.
Huh?
They are the Rameshwar and Salaur are the informants here, my
No,
lord.
below mentioned accused.
Yes, and the
Where
accused
the
is
below mentioned accused?
page number 68. Bilal Hussain,
Bilal Hussain.
who is an practicing advocate, my lord. He was made an accused, my lord, stating that he has stolen the
Oh, he has no license.
license.
No,
Yes,
no, he has no license
he is having the license.
to seek immunity.
My lord, page number 8
To
is the
seek immunity.
my lord.
Bilal Hussain. Who
Bilal
is he?
Hussain. False case, my lord, totally.
No,
that is
Bilal
why-
Hussain is not a petitioner here.
No, my lord, I
Huh?
am pointing out because, my lord, same case, my lord, I am coming
So
one
in
by
the FIR, Bilal Hussain was named as an accused.
accused, and he was
What
granted
is
bail.
this 331 and 303, mister?
My lord.
This offense BNS.
Lordship, in this case, bail was granted by this honorable court.
1 minute. Bail may be granted.
Bail was
Number
granted, page
submission
number,
is a 16/9/2024 for stolen materials.
page number
So a
73.
practicing advocate stealing materials.
My lord, that is totally
Stone,
first
sand,
case.
brick
That is why final
wood.
report submitted, my lord.
From the House of Permanent Office of Assam Gana Parishad,
My lord.
Dolgaon LSC.
In this regard, a civil case is going on, my lord.
No, wait, civil case, don't say civil case anytime. Let us hear the, read the complaints first.
My lord.
Civil case is not the only condition for staying proceedings of
My
criminal case. It may be one of the aspects.
my lord.
Yes, what happened to this FIR?
Right.
What happened to this
My lord, the
FIR?
investigation was completed, my lord, the final report submitted.
Where is that?
My lord, that final report number I have stated, my lord, the report is not with me, my lord. I could not annex.
Then what is
Lordship,
this
page
page
number
75?
73 may be seen, my lord.
73?
73 is the order passed by this honorable court to the petitioner. To not the present petitioner, but to the husband of the petitioner. At that point of time, the affair was lost.
No, you are
Lordship, page number 75 is the impugned CR case, my lord. 75.
This is Moriam Begum.
Moriam Begum.
The
Moriam
first one
Begum.
is Bilal.
Bilal, husband or wife, my lord.
Maybe.
My lord. My lord, accused number 4 is Moriam Begum here.
No, this is an FIR, mister.
My lord.
First page 67 is an FIR.
FIR.
It was registered as Kharupetia Police Station, case number 108.
Yes.
Right?
My
And what happened to this case?
Final report submitted, my lord.
Final report submitted.
My lord.
Then,
My lord, in the meantime, another affair was lost. That was not accepted by the police because same cause of action. That is stated in this CR case. Lordship, if you lordship kindly come to page number 81, my lord, para 3 only, my lord. Vernacular, my lord. 81, para 3. উক্ত সংক্রান্তে খারাপিয়া থানার 28/9/24 তারিখে এজাহার দাখিল করা হয়েছিল তো থানার পদক্ষেপ লোৱা নাই। Same incident and date of occurrence may be seen in the same page, page number 81 may be seen. Paragraph 2. জুয়া ইংরেজি
where is the head and tail of this complaint?
মানে headline page number 70.
Head and tail. Page 81.
It starts from
Where is the head and tail?
my lord starting page.
First part and last part. Where are
Yes, yes. First part is page number 76, my lord.
But 76 is a type portion.
Yes.
The original portion.
No
yes,
type
type.
portion. Where from you have typed?
My lord, I have typed, my lord, page number 79 because There is Assamese portion is there. That is why I have typed out.
Don't keep piecemeal. I don't entertain.
Page number
I am
81 and
repeating.
79.
40% is
Half,
not there.
half part of the complaint should not be annexed.
My
Either you do it full or
my
don't.
lord, other part is typed copy, my lord.
That cannot be.
My
How
lord,
can I believe? Out of 10 cases, I find infirmity in 8 of the cases.
my lord, page number 76 onwards, SCR is started, my lord. In the meantime,
Don't
two pages.
annex as per your own choice. Give the opportunity to the court to look at the full complaint also.
No.
First page missing, last page missing, and you have translated the part. Where is the vernacular version of page 76?
Vernacular. Page 76 is the,
Where is the vernacular version?
this is the vernacular, my lord.
This is vernacular.
My lord.
English is vernacular.
My lord, I have not typed this, my lord, because English type copy is.
Oh, according to your choice. I am
But,
dismissing it.
On the next occasion, I can type all this. my
Hard,
lord.
Mr. A. Ali. Don't play this type of thing before the court. So many things are there. You have not typed. I have found at least 2-3 pages of the complaint. Is it not?
That is my fault, my lord.
Hmm?
I am sorry, that is my fault. But I thought that the Assamese
So
portion I have.
think whatever you like. We'll also think
My lord, I.
whatever I like. Hard. So you think, I think.
My lord, I'll type down.
Result is dismissal.
Next
Hard,
occasion.
Mr. A. Ali, Learned Counsel for the petition and RR.
My lord, I will file an affidavit,
Public
my lord.
prosecutor. No, I'll not excuse. I'll give liberty. For Learned Counsel, additional public prosecutor for the respondent state. To stop the proceedings of CR case number.
Yeah, 178 oblique 2025.
178.
My lord.
So 2025. Has been presently pending before the Court of Learned Judicial Magistrate First Class Dorong, Mongoldoy, has been silenced in this petition. Full stop. On perusal, the complaint, the copy of the complaint of so-and-so case number has been partly annexed. Full stop. Meaning thereby, the entire copy of the complaint has not been found annexed to the criminal petition. Full stop. In such view of the matter, this court is of the view that this kind of criminal petition cannot be entertained where the entire copy of the complaint is not annexed. Full stop. Mr. Ali, Learned Counsel for the petition, has submitted that the petitioner be granted leave to withdraw this petition with the liberty to file a press
All right.
with proper particulars. Full stop. In view of the liberty so sought for, this criminal petition is dismissed on withdrawal, with the liberty as paid.
All right.
Item 26,
May it please a lot. Lordship, have a look at page 12, my FIR.
PS12.
Page 12, my FIR.
Amjad Ali.
Amzad Ali. Amzad
Informant.
Ali is the informant, man.
Yes.
The petitioner before your lordship is accused number
Who are
1
they?
and 2.
Accused number 1.
1 and 2.
1 and 2.
1 and 2, madam. Now may I read out the,
Yes, please.
with due respect and begs to state that about a month and half ago, accused number 2 mentioned above proposed the marriage to my sister, namely so-and-so, for accused number Asabul Haq. Then I reject the marriage proposal due to minor.
Accused number 1 proposed the marriage.
Yes. But
What is the relationship?
cousin brothers, madam.
Okay.
Cousin brother,
Proposed the marriage to my sister for accused number 1. Okay.
Since then, the accused party.
Can I reject the marriage proposal?
Madam.
Okay.
Rejected the proposal.
Who is he?
Madam, he is the
Elder brother.
Elder brother of the victim, my lord.
Ah.
Since then, the accused person have been seducing my sister so-and-so with various temptation, and since the proposal of marriage, the accused number 2 having been visited my house frequently. Yesterday on so-and-so at about 6 p.m. in the absence of other family members, the accused number 1 with the conspiracy with accused number 2 took away my sister to some unknown place. The accused number 3, Monaf Ali, was informed by phone that your son Asaful Haq forcefully took my sister to an unknown place, and the accused number 3 informed me, promised to return your sister within half an hour. But all the accused above together let my sister so-and-so to stay together with accused number 1, Asadul Haq. in a different house all night. And the accused number 1 raped my sister. Today on 16/7/23 at about 6 p.m. with the help of Abdul Mojid and Anwar Hussain of the same village they accused to hand over my sister to the house of grandfather. So here, my lord, the police, after investigation of the case, my lord, filed the charge sheet, my lord. Now your lordship will turn to the charge sheet, my lord, at page 24, the relevant part, my lord. Second paragraph, my lord. During investigation of the case, recorded statement of the complainant and witnesses under section 161 CRPC, drawn up a rough sketch map of the place of occurrence with index, seized original admit card of Seba and wearing clothes of the minor victim girl, medical examination of the victim girl and received final medical report under section 164 CRPC statement of the victim recorded judicially and received a final Xerox copy of it, arrested 3 persons and enlarged them on bail as per honorable court's order of pre-arrest bail. Send the seized wearing materials of the victim girl so-and-so mallet drawn blood sample of the arrested main accused to the FSL Kahilipara for DNA analysis and comparison and receive final FSL report. In course of investigation, a prima facie case is well established against the arrested accused person under section so-and-so mallet. And my lord, third person was my lord, he was not charge sheeted. Moreover, during the investigation, prima facie it is found well established against arrested accused Ashabul Haq, son of so-and-so, and district so-and-so, my lord, under section 363-34 IPC read with section 4 of POCSO Act, and against Ainul Haq, my lord, committed crime stated of. So, my lord, against these 2 persons, my lord, charge sheets were laid, my lord. So in the meantime, my lord, that victim girl, my lord, now she is a major, my lord. At that point of time, she was, my lord, date of birth was 3/4/2006, my lord. Now, my lord, the victim got married with some other person, my lord. Now,
Father is compromising.
yes, my lord, the informant has filed an affidavit, my lord, that have been
Informant has filed, the victim is not.
not filed. So if required, my lord, I have just asked him, my lord.
Will issue notice.
Yes, ma'am, notice at this.
Had Mr. N.J. Dottal and counsel for the petitioner and Ms. R. Kosik and Tradition Public Prosecutor for the respondent state of issue notice returnable in court. Whereas Mr. Kosik has appeared accepted. Formality is dispensed with the petitioner. Let the lady come.
My lord.
Will not accept.
Yes, I'll. In the meantime, a notice may go to respondent number 2.
No, you implead. Why you have, no, who is the person who has suffered?
Then I may be allowed to implead, my lord, the victim, my lord.
You allowed and will issue.
My lord.
That notification. that
17.
Memo is.
Yes.
17.
7 something?
17.
Okay, Mr. Dottal and N.J. Dottal and counsel for the petition. কি notification আছিলে mention কৰিব নে কিবা দে বুলি কয়
Implead কৰি দিয়া।
এই implead ৰ যে আচ্ছা এখন লিখি দিব has sought 2 days time to file so and so to implead
the victim
as the party respondent the submission that the victim has become major in the meantime. Otherwise, minor cannot be
yes, my lord. A week's time.
Week's time. List the case. Next week.
Next week. I'm obliged.
Supplementary list, item 47.
Economic food and retail industries.
The petition is for quashing a complaint case, Your Lordship. The petitioners before Your Lordship is a private limited company and all the directors.
Did you deliberate on that day or what?
Yes, Lordship, I sought time to bring on record the summon, Your Lordship. That was not annexed earlier. I have filed an additional.
Summons.
The summons. I have filed an additional affidavit.
What is the ground? Tell me.
Lordship.
This is a case under what?
This is a case involving section 406-420, Your Lordship, together.
406-420.
The facts briefly.
Let us read the affair. Oh, sorry.
Lordship, complaint case is. Complaint is at Annexure 7, page 30. starts there. All the directors are made party of the company.
1 minute.
And from page 34,
Chief
the fact-
Judicial Magistrate, Aditya Industries. Economic Science.
the fact starts from.
You are
page-
from Maharashtra?
Maharashtra.
Okay. 1, 2, 3.
This
Four.
is the submission.
Maharashtra.
All the directors are from.
Huh?
There was an.
So how many accused? 1, 2, and
Three
3,
directors.
4. Okay.
So the facts, your lordship, briefly, is that this proprietorship firm ordered for a machine from us, your lordship. Thereafter,
Let us see the.
lordship, page 34 onwards is the facts. In para 3, they have stated we have a long business relationship.
Did you reply to any of the notices?
Yes, your lordship, that is not placed by them, your lordship.
Huh?
That is not placed by them in the complaint case. There is an email, your lordship, it will clarify everything. Page 20, annexure 4.
20 and extra 4.
They have not placed this on it. There are previous emails as well. This was the final email. This explains it all.
Part Mr. Vijay Mukherjee, Learned Counsel for the petitioner. Also the instant petition under section 528 BNSS is prepared, seeking quashing of the proceedings of complaint case number 1E7/2024, presently pending before the Court of Learned Judicial Magistrate First Class, Kamrup, Metro Guwahati, at Guwahati, and an order. Okay, full stop. Para. The Learned Trial Court has taken cognizance on the complaint and issued process against the petitions. Full stop. Para. It is stated that the petitioner number 2, 3, and 4 are the directors of the petition number 1 company. Full stop. In para the complaint case, in the complaint case, comma, the respondent complaint has entirely alleged that he placed an order for supply of his 34, quote unquote, food processing machine, rectangular fryer with heat exchanger, tilting system, oil tank, thermic fire within bracket regular, unquote, and made an advance payment of rupees 13 lakhs. Post up, when despite remitted reminders, comma, the petitioners did not supply the machine for which the respondent complaint had placed order, comma, the respondent complaint had has instituted the proceedings of so and so, alleging commission of theft, alleging commission of the offences under section 420 and section 406. The petitioner has alleged that the sum of rupees 13 lakhs was only an advance consideration, and the machine was to be supplied only after payment of full consideration, which was agreed at how much?
26 lakh,
26 lakh?
84,500, including
So,
taxes.
as the respondent complainant did not pay the balance consideration, comma, the machine was not supplied, full stop. The matter would require consideration, issue notice, returnable in 4 weeks. The petitioners shall take steps for service of notice upon the respondent by registered posted AD as well as by usual process, having regard to the contents of the complaints made. Having regard to the nature of allegations made in the complaint of complaint case number 7, so, and comma, this court is of the privacy view that the ingredients of the for the offences under section 406 and section 420 of the IPC appear to be absent. Therefore, it is ordered, comma, in the interim that the further proceedings of so and so case number presently pending before the court of so and so shall remain suspended till the returnable.
For admission, item 27.
May I please, Lordship?
Yes. Offense.
Appeal, my lord, against conviction, my lord.
Conviction.
Or the
Page.
judgment and order dated, my lord, 16/6/2025, my lord. Page 11, my lord.
Will issue notice that this
Notice, my lord.
hard, will admit.
My lord.
Hard, Mr.
S.A. Sikdar, my lord.
Sikdar, Nanak Council. For the appellant, accused appellant. And Mr. R.R. Kosik. Public prosecutor, respond number 1. This criminal appeal under 415, liquidable. Judgment and order. It is 16/6/2025. Court of Learned Special Judge, Rungia, Kamrup, bracket of Special Court, Special FOXO case number 07/2015, arising out of Paihata Sareli Police Station case number 145/2013. Conviction under T76 read with 511 IPC and section 10 POXO. Rigorous imprisonment 5 years, fine 5,000, in default 1 month under section 376/511. Similarly, under section 10, 5 years, 5,000, in default. Assign simple imprisonment for 1 month. Concurrently, we have gone through the context of the memorandum of appeal. The appeal is admitted for hearing. Case records of so and so we call for, issue notice, returnable in so and so. The appellant, as Mr. Kosik appeared 1 for 1, then steps in terms of practice direction. Officer in charge, so and so police station on or before the returnable date. But Mr. Sikdar and counsel for the applicant appellant, R.R. Kosik, opposite party, that's respond number 1. Then 430 applicant, the BNS, the applicant as the appellant, issue notice, so and so. The Tips opposite party number 2 seen. The prayer for suspend prayer made in this interrogatory application will be considered after receipt of the TCR.
Hello.
28.
Yes, so
appealing against conviction.
what is the conviction?
Is section 366.
3?
66 IPC Lordship. Kidnapping.
How much?
3 years rigorous imprisonment with 5,000 rupees fine.
Yes.
But otherwise, victim has implicated him, my lord.
Victim is of what age?
And that age, going by this order, my lord, age has not been proved, my lord.
What is the content of the FIR? What is the story how she was kidnapped?
Page 29, my lord.
Lordship.
Page 29.
9 of
Vernacular is at page 33, Lordship.
Page 29.
33. Married, Lordship.
Okay, English translation. Majida Begum. Okay, Scooty. Okay, then what is the age?
Lordship, that is not proof.
What is the finding of the trial court?
My lord, based on her statement and other witnesses, my lord, 3, 4, 5 PW, my lord, court has convicted.
What is the age?
Age that has not been proved.
That is,
So that is why 366.
Yes.
Initially,
And who are in the Scooty? The accused and
My lord,
the lady.
brother-in-law and that particular.
How many occupants?
3.
3.
3. Otherwise, 3 years punishment, man.
What? Mr.
BP Sharma.
B.
P Sharma.
P. Sharma.
BP Sharma.
BP Sharma.
What?
Okay, learned counsel. For the appellant, accused appellant, and Mr. R.R. Kosik. Learned additional public prosecutor for the respondent number 1, State of Assam. Judgment and order 31/5/2025. Additional Session Judge, Dibrugarh, Trial Court, Sessions Case Number 117/2018. Accused convicted under Section 366 IPC. And he is sentenced to rigorous imprisonment for 3 years and to pay a fine of ₹5,000 in default payment of fine to suffer to undergo simple imprisonment for another 3 months. We have gone through the so-and-so. Female PD is admitted for hearing. Case records of so-and-so be called for. Issue notice, return within 4 weeks. R.R. Kosik. Respond number 1. Registered post. Respond number 2. Registered post with AD. Right. Mr. B.P. Sharma. Learned counsel for the applicant appellant. R.R. Kosik. Learned additional public prosecutor for the opposite party. That's respondent number 1 from a state of Assam. The applicant as the appellant has prepared the accompanying criminal appeal number so-and-so against the judgment in order to expense But the land council, sorry, as per prosecution story, comma, the victim was abducted from the premises of Saulkoa High School by the applicant with the assistance of his brother-in-law, comma, Ibrahim Ali. Full stop. A charge under section 366 IPC was framed against both the said two charge-cited accused persons. Full stop. During the course of the trial, comma, the prosecution examined 8 number of witnesses to bring home the charge against the two accused persons. Full stop. At the end of the trial, comma, the accused Ibrahim Ali has been acquitted from the charge under section 366. Full stop. The applicant appellant is the sole appellant has however been held guilty of the charge under section 366 IPC. Full stop. Para. As per the testimony of the prosecution witnesses, more particularly PW2 or PW3?
PW2, check. Victim is PW2. PW3.
So as per the prosecution case, comma, the alleged victim, within bracket, PW2, was taken from a place by the applicant appellant on a scooty. Full stop. The age of the victim, age of PW2, comma, who was stated to be 15 years of age, comma, was not ascertained during the trial. Full stop. Even the scooty, whereby the victim was allegedly kidnapped, abducted, was not seized. Full stop. Para. After hearing the learned counsel for the parties, comma, this court is of the considered view that the applicant has made out a prima facie case for suspension of the execution of the sentence passed against him and for his release on bail. So deliver suspension 10,000 on COD satisfaction trial.
Deep progress.
29.
Memo to दिया.
Yes.
Yes, Miller.
Mr. Ahmed.
5 years conviction, Miller.
Huh?
Under section 366A.
How much?
5 years, Miller.
5 years.
Yes, Miller. But in this case,
Minor.
As per FR minor, but in the evidence, Miller, the PW1 is the father and PW2 is the victim. They stated herself.
Oh, 18 years.
Yes.
Below 18.
Below 18 years, Miller. Above
below
18 years.
18.
Yes. No, my lord. As
It is
per
proved beyond all reasonable doubt that a victim.
May it please your lordship. This is a statutory appeal.
NDPS.
NAPS, your lordship, the petitioner.
10 years.
10 years and fine of 1 lakh in default, simple imprisonment for 2
Y.S.
years
Mannan.
under section 21C.
Y.S. Mannan. Madam, you are for
NCB Lordship.
NCB.
Lordship.
Miss
N Kakoti.
N.
N Kakoti.
Kakoti. You are for Kyle.
Lordship.
Okay, Mr. On behalf of SC Kyle. Standing for public prosecutor. He is public prosecutor.
Standing counsel.
Standing counsel NCB. Just fine, answer. How many petitioner? One, single.
Yes,
Only he was convicted.
he was only convicted, the others were acquitted.
Acquitted. Okay.
Here, your lordship, I also have a I for,
That will be considered only after.
but here, your lordship, they have mandatorily the period of half the period of sentence have already been completed. More than 5.5 years in custody. Section 436A will be applicable.
Is it so?
Yes, and that I have a
Is it
judgment.
applicable in NDPS also?
Yes, yes. I'm just sending the judgment of Satyendra Kumar NT. Here, your lordship, the court is very specific.
Yes, madam. What do you say about that? Possibly.
Yes, sir.
Special Windmaker, NDPS case number, Kamrup, Metro, Guwahati. Special court. NDPS case number 29/2020. Conviction under section 21C, small c, 29 NDPS Act. Rigorous imprisonment 10 years. To pay a fine of rupees 1 lakh.
1 lakh.
In default of payment of fine, to undergo simple imprisonment for another 2 months. Appeal is admitted for hearing. On to so. You should not. This will
This judgment of Satyendra Kumar and versus CBI. Here, I'm relying on page 46, sorry, 46. It's here 436A has been discussed by the Honorable Supreme Court and how it should be provided you. In 47, the detention has, now I'll read your lordship, para 40. Section 436A of the code has been inserted by so and so. The provision has got a laudable object behind it, particularly from the point of view of granting bail. This provision draws the maximum period for which an adult prisoner can be detained. This period has to be reckoned with custody of the accused during the investigation, inquiry, trial. We have already explained that the word trial will have to be given an expanded meaning, particularly when an appeal or admission is pending. Thus, in a case where an appeal is pending for a longer time, to bring under section 436A, the period of incarceration in all forms will have to be reckoned, and also for
what is the provision in BNSS?
BNSS I have given you, just a moment.
Which is the provision?
Yes, just a moment. Right. BNSS, your lordship, the provision is 479. 417.
Why the judgment is silent about the page 15, last column?
Page
15, last column.
In the IA?
No, no, in a judgment. Generally,
Okay, okay.
the calculation is made by the
Uh-huh.
trial court. It is silent. When you were taken into custody?
He was taken into custody, your lordship, on just he was taken into custody on 39/2019. 30.
So it. Yes, Miss. We are putting you on notice
Notice my.
within 1 week. 1 week,
Lordship.
not more than that. If it is 2019, some mention about public prosecutor is there in.
Yes, it is there. They have to be heard. They have
to be heard. At least they should be put on notice. Yes. When
Notice may be,
heard Mr. Y.S. Mandan, applicant appellant, Miss So-and-so, SC Cal, and the instant
11 or-
interrogative application under section 430.
11 or
430, 2 BNS, is preferred by the applicant appellant seeking suspension or execution of the sentence passed against him and for his release on bail. It is the prime contention of the applicant appellant that the applicant appellant was taken into custody on
39/2019.
2019, and since then he is in incarceration. Full stop. The applicant appellant has started that the learned trial court, special court, has convicted him for the offense under section 21C and read with section 29 NDPS Act, and he has been sentenced to undergo a term of imprisonment of 5 years. Full stop. If counted from 39/2019, the petitioner has, applicant appellant has spent more than 5 years in custody, and as such, the provisions contained in section
436A and of
uh,
CRPC and 479 BNS.
CRPC stroke
479 BNS.
BNS will come into operation. Issue notice returnable on.
11.
Hurry, no? 14.
11 Lordship. 14.
11.
Lordship.
Good. 11/8/2000. No, 14/11 good fix.
Lordship, 14 Mr. Cal is not there.
Cal is not there. Okay. After independence,
11,
you will be there. 18.
18 Lordship.
No, there are too many cases fixed, Mr.
12 already
Too
made.
many cases.
Lordship.
18.
He will
18
be out of station.
18 is also.
Also Lordship. Till 22 Lordship.
Okay,
Let it be 11, lordship. Let it-
11.
We'll see on that.
The-
Apply, sir.
Right, Lordship.
For suspension of sentence will be considered under returnability.
Masud.
Item 31.
You take back this until.
Hey, Lord.
Kiman?
May I please, Lordship?
Wait.
One of the two appellants before,
Mr. Borbhuya.
yes, for two appellants before your Lordship, and
Hmm?
they are convicted, my lord, under section
304.
4 part 2, my lord.
How many years?
7 years.
7
my
years,
lord.
man.
PM Borbhuya.
No, sir.
Both have been convicted.
Yes, my lord.
How many appellants?
Two appellants, sir. Appellant number
Kanu
one,
Piklu,
one,
Kanu
my lord,
Piklu, huh?
very seriously ailing, my lord.
Kanu Piklu. Additional Session Judge, FTC Kasar, Kilsor, Sessions Case number 87, 2011. Conviction. Have been convicted for the offenses under section 304, part 2, section 325 and section 341. Read with section 34 of the Indian Penal Code. for the offense under section 304 part 2 IPC, the appellants have been convicted for the have been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 each with default stipulation. For the offense under section 325, simple imprisonment for 1 year and to pay a fine of rupees 3,000 with default stipulation. They have been sentenced to pay a fine of rupees 1,000 each for the offense under section 3441/34, IPC with default stipulation. The sentences are ordered to run concurrently. Contruta so and so admitted. Case records, issue notice as so and so as appear accepted. No formal notice. Then I issue notice 430. ENSS issue notice like indicative prayer will be considered on receipt of the TCR. And liberty to mention the matter immediately on receipt of the TCR. Yes.
32.
My lord, it is, my lord, provided to run, my lord, consecutively.
Huh?
Consecutively only.
Okay, consecutively then. Consecutively.
My lord, one thing, my lord, IA, my lord, there is the IA.
Immediately you are given liberty after receipt of the TCR to make a mention for listing.
Obliged.
Let's see, your lordship.
Yes.
Statutory appeal, lordship. Appellant was convicted under section
How much?
51, 7 years.
Oh, 7 years.
With fine and deposit.
You are what? You are Black Panther lover.
Yes.
Black Panther lover. You are fond of Black Panther. Heard Mr. L.R. Majumdar. Accused appellant. B. Sharma. Special PP.
My lord.
Wildlife.
Wildlife.
Further.
Wildlife was not made a party, my lord. Only
Okay.
made public.
Now I will reflect it
My lord.
in the cause list. That will
My
do.
My lord.
Okay. Page 15 আছে. Session Judge Baksa at Musalpur. Judgment and order 13/6/2025. Special W within bracket P case number 12/2018. Section 51 Wildlife Protection Act as amended. Rigorous imprisonment for 7 years and fine of rupees 50,000 each in default. Simple imprisonment for another 2 months. Gone through the memorandum, admit, records called for, issue notice as Mr. Sharma has appeared in a precepted. Extra copy. Release the case after 4 weeks. The name of Mr. B. Sharma, land a special public prosecutor, wildlife be reflected in the respondent side in the call list.
Alright.
I same. I go to Nisla. Applicant as the applicants. I go to Nisla. Make a mention.
Alright.
33.
My lord, here in this case, 304 part 2, my lord. It is the accused, I am accused number Kamalendu Dev, accused number 2. In item 31, most possibly the other two appellant.
Okay, you are with that Kanu and Piklu.
No, I am.
You are with Kanu and Piklu. You are the Kamalendu.
I am Kamalendu.
The other two Kanu and Piklu.
Yes.
Same Borbhuya is na. Same Borbhuya jitu item asil na. 31. Same.
Lord, I have filed application.
No discrimination, same.
Same, but
same order.
Only one paragraph I want to show, my lord.
Same order. You are convicted.
I know, my lord.
Sentence,
Same order.
sentence same.
Only one paragraph.
I will not make discrimination.
For my satisfaction only.
Borbhuya will cry foul.
For my satisfaction only. my lord. For my satisfaction only. Page, paragraph 57, page 52.
Page
52, paragraph 57. Only one paragraph.
absolutely.
It is a
Absolute.
case of 323, my lord. It is a case of 323, my lord. Not
No. We'll see. That is a matter of appreciation of evidence.
yes.
It is not palpable. Expressly on the record to grant you on the
And-
first date.
All along cooperated.
Because it was not a premeditated sudden fight. That is why the court has held it is a case of murder, but because of the exception under exception 4, it is brought to 304 part
Part 2.
2.
Part 2.
It can be done, but it can go straight away or through 302 under exception. Both can be done. Go to Vivian. Yes.
34.
Maybe please, your lordship. The conviction is under section 326 for 4 years.
4 years.
The impugn is page 4, page 15,
21-6.
page 14, and sentence is at page
4
39.
years. Yes. 307. Or convicted under what?
326.
326.
326.
What is the sentence?
For
4 years.
4 years.
The man died or did not die?
No. He recovered.
Recovered.
Previous heart.
Grievous hurt.
Grievous hurt is there.
Yes.
Page 41 is
Arrow.
Arrow, my lord.
How many times?
2 times.
How many times? By arrow?
2 times.
2 times, my lord.
2 times.
Spinal injury is there.
133 days already in custody.
Yes.
So about 150 days already in custody.
Yes.
June, July, August. 40. About 175 days custody. Arrow.
Arrow.
And come to page 20. Dispute occurred at a plot of land which
Yes.
was in possession of the accused.
Yes.
Aggressor was the injured. Hurt, Mr.
My lord, here he was constructing a wall of a person called Noyan Das.
Noyan Das was the main man
Noyan Das.
who had employed this.
Yes.
You are Mason.
I'm Mason.
Who is Mason?
I'm Mason.
Victim.
my lord. Victim.
Okay. Let him go 175 days, bow and arrow. Hard, Mr. S. Dihinya, Learned Counsel for the accused appellant. And Mr. R. Kosik, Learned Additional Public Prosecutor for the respondent state. Page. Jasmine, is that page?
It's page 12. Page 14.
14.
Annex A. An order sentence.
21/6/2025. Additional Sessions Judge FTC Lakhimpur at North Lakhimpur. Sessions case number 134 within bracket NL 2018. Sentence 326 IPC, rigorous imprisonment for 4 years and to pay a fine of rupees 20,000 in default of payment of fine, to undergo rigorous imprisonment for a period of 60 days, peruse the contents, admit, records be called for, issue notice as Mr. Kosik, so and so. This is the case after 4 weeks. Third, Mr. S. Dihinga, learned counsel for the applicant appellant, and Mr. R. Kosik, learned. How many appellants?
For Lordship,
Appellant.
five person was convicted, but we
Okay.
have filed an appeal by 4 appellants
Okay.
now.
Accused appellants. R. Kosik, R. Kosik. State.
84, 85 page, this
Uh,
sentence.
Judgment dated 10/7/2025 and an order on sentence dated 11/7/2025. Additional Session Judge Morigaon, Sessions Case Number 97/2017. You are A1 too?
Lordship, A1, A3, A4, A5.
A1, A3,
A4 and A5,
A4, A5.
page 19.
The accused appellants in that trial were named as A1, A3, A4, and A5. Full stop. The accused appellants have been found guilty of the offenses under section 30, 430,
341.
Okay, 307, read with section 34. 326, read with 34, 341, read with 34, is 20 does. So for the offense under 307, read with so and so, RI for 10 years, fine of rupees 10,000 each, with default clauses, stipulation. 326, 34, RI for 10 years, fine 10,000 each, default stipulation. 341, read with 34, simple imprisonment for 1 month, with fine of rupees 5,000 each. Contents, admit, records, notice, Kosik, respondent state. I same, huh?
Lordship, in respect of IA, Lordship, we have filed 2 IA, but if you Lordship permit, we can submit 2 lines in respect of one IA, Lordship, because
Which
he
item?
IA number 824, Lordship, Abdul Majid.
Okay, let me pass this order. 823. Diullah, applicants, appellants. 3 applicants, appellants. Returnable 4 weeks. The Learned State Council is at liberty, Learned Additional Public Prosecutor is at liberty to file. Shall make an endeavor to file objection to the instant interrogatory application. Yes, if it is so, then whether opportunity is to be given in this case?
Lordship.
When opportunity is to be given? Under 389 CRPC?
My lord, if it is convicted for 10 years, my lord.
10 years.
10 years.
Then opportunity.
But then, Lordship,
You give more priority to this. What is the ground?
Lordship, it is medical ground. He is 76 years of age. And
Okay, I'll
a lot
record
of
that.
hearing impaired, Lordship, both ear, and
Okay.
other ailment, osteoporosis, Lordship. Lot of medical documents are there. We have-
76 years of age
Yes,
and
hearing impaired,
hearing impaired.
both ear.
Both years.
And also, Lordship, he is having this osteoporosis,
Okay,
Lordship.
Mr. Ragula, Learned Counsel for the applicant appellant, Mr. R. Kosik, Learned Additional Public
Osteoarthritis
Prosecutor for
injury.
the opposite party does respondent state, the applicant as the appellant, likhibah, Pakistani sub same. The Mr. Ragul, Mr. Ullah, Learned Counsel for the applicant appellant has submitted that the applicant appellant is presently applicant appellant who is in incarceration, is presently aged about 76 years of age. So the applicant appellant is hearing, the hearing of the applicant appellant is impaired, full stop. In addition, comma, the applicant appellant has suffered from a number of ailments. And in support of such ailments, comma, the documents are made part of the instant application. Full stop. Mr. Kaushik, and additional public prosecutor has sought, has submitted that the state will file an objection to the instant interlocutory application seeking suspension of sentence, execution of the sentence. Full stop. The learned state, learned additional public prosecutor shall file its objection on or before the returnable date, so that on the returnable date, the instant application can be considered.
That's a date maybe it's in effect.
Then all have to be made returnable same date করে দিব, all have to be made.
এইটো কিমান?
For orders, item 37.
This is a leave petition, my lord, against the appeal against acquittal, my lord.
138. 138.
My lord.
Have you read this salary, I think salary?
Yes, my lord. Yes.
Then,
Nowadays, my lord, it is victim, considered as victim, 372.
and the court judgment is retrospective in effect.
My lord.
Then, what is the proper court to file an appeal?
It will be session court then.
Then why you are here?
My lord, lordship, well, close it, giving liberty, my lord.
Yes, Mr. Kaushik. Close this. Appeal is to be filed before the session court. Heard, Mr. R. Do you have the judgment?
Yes.
We are not party.
You assist. Just don't shy away by saying that we are not a party. Do you have the judgment?
The judgment citation name is there, my lord. MS Celestium
কিন্দাখন এটা দিছিল ন?
Financial.
কিন্দাখন যেটা দিছিল কালি নে পৰহি? মোশনতে এনকে কলিতা।
Messrs Celestium Financial versus.
Okay. এই মোশনতে আছিল কালি নে পৰহি? Okay. Liberty to approach the appropriate appellate forum.
Item 38.
Review.
Review on a short point. My lord, the petitioner had filed a writ petition claiming pensionary benefits. Now, my lord, lordship's order will find at page 123. Now, while the matter was taken up, my lord, a concession was given by the Learned Standing Council Revenue as well as, my lord, by the government advocate.
That is the problem.
Yes, now, my lord, that the matter is similarly situated with other persons, my lord, and which are already covered by dictum of this honorable court, my lord, in some earlier orders. Accordingly, lordship has, my lord, disposed of the writ petition, directing the authorities, my lord, to grant ex post facto confirmation of service. And they had relied, petitioner had relied on a office memorandum, which says, my lord, that if there
is no period of limitation for seeking review.
My lord, this is, my lord, the review, my lord, I have filed under Article 215. But technically, my lord, otherwise it is 30 days.
So under what?
My lord, I have filed this review under Article 215.
215?
215 of the Constitution.
215 is contempt.
215, my lord, court of record, my lord.
No constitution. Show me that no limitation is there. Huh?
My lord.
Okay, we have all the powers.
My lord.
But it is
But otherwise, my lord,
2022,
22.
after 3 years.
No, Lordship is absolutely correct. If I,
Show me something
if I had,
for which, because I have no knowledge, that 215 can be invoked in the garb of review.
in the garb of review. That is otherwise permissible. my
Because
lord.
one order will have effect, cascading effect on some others.
No, no, absolutely.
Right.
Absolutely.
Is that will issue notice thereafter.
Well,
Notice has to be issued,
notice has to be
but
issued.
question is first satisfaction.
Absolutely correct. Absolutely correct.
You show me definitely
And-
that, because otherwise, all I have judgments I have read is for order 41, the contours of review.
Order
Right.
47, rule 1.
Section 114, right, CPC. And the contours of review within that.
Yes.
But so far I have heard for the first time that there is no
115.
period of limitation for seeking review
Yes.
in if 215 article is invoked.
Article 2.
Show me definitely.
Absolutely.
I am ready to learn. No issue.
My lord, I'm so grateful.
When you want.
Lordship, can it be, my lord?
But concession was made by you. Show me the
Concession
law.
was made by us. That is the difficulty because
Otherwise, I don't. Otherwise, without examining, I don't.
no, but absolutely.
Otherwise, pass
Because
on.
otherwise, my lord, why we have not filed an appeal? Because there is no pleadings, my lord.
2-0.
2-0. My lord, can it be, my lord, on? Can it be
All
on?
these are full. This week is not possible.
My lord, then thereafter, my lord, 26th, my lord, if it is possible, 26 or 27. 2-0, some difficulty on my part.
22, 22nd.
22nd, yes, my lord,
22nd.
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 Yes. I'm so
Okay,
obliged.
on the prayer request of Mr. R. Babudai, Learned Counsel for the petitioners, list the case on 22nd August.
I'm obliged.
Item 40.
May I please, your Lordship?
We have to issue notice. No
Lordship,
point.
delay is of Lordship for 79 days,
Not a small one.
Lordship.
A private party is involved.
Grounds is also dear, Lordship.
Private party is involved, sir.
Yes, yes, Lordship.
Yes. Heard, Mr.
M. Rahman.
M. Raman, applicant. R. Kosik, Additional Public Prosecutor for the opposite party, State of Assam. The instant interlocutory application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 479 days, which period of delay is stated to have occurred in preferring the accompanying criminal revision petition. Issue notice returnable in 4 weeks as Mr. Kaushik, opposite party 1. No formal notice. The applicant shall take steps for service of notice upon the opposite party number 2 by registered post with AD as well as by usual process within 3 working days from today.
Obliged, Lordship.
41.
Haldar.
102 days delay. POXO case.
Condon?
My lord, POXO.
Oh, no point. We are doing 25 by the trial court, the matter was forwarded from the jail authorities to the District Legal Service Authority. Post of finally, the Guwahati High Court Legal Services Authority, Principal Seat Guwahati, provide office letter dated 3/6/2025 had appointed the legal aid counsel to prefer the connected accompanying criminal bill of sufficiently so and so so and so. Yes, Mr. Gogoi.
For correction of the bridge name, Lordship, which was mentioned.
Who is your opposite party? Mr. P.K. Gugoi, learned counsel for the applicant.
The
Petitioner is present.
The Borpujari was CR SC revenue.
As there is no representative on behalf of the respondent, as the learned counsel for the respondents are found absent, place the case on. Some correction?
Yes, Lordship, only for
Monday,
village name,
Monday,
Lordship.
Monday, no, Tuesday.
Tuesday.
We'll dispose of that. You bring some of them
Lordship,
together, we'll dispose of them
next Monday, Lordship.
next Tuesday. Same, 46 same.
Lordship, next Monday, I am
Item
not
46
available.
is same. Tuesday.
Lordship, I am not available that.
Make it available, make it yourself
Lordship.
available.
12/8.
12 feet. Oh, you are going somewhere.
I am going to Sibsagar, Lordship. That is
When you do one there? 18?
18, Lordship.
Okay, 18. But make sure that the other councils are available.
Lordship.
Yes, Mr. Day. Why it is there for orders?
Order, sir. Service report is awaited, my lord. Omniting,
Service. R.D. Learned Counsel for the petition is present. And Mr. So-and-so also. Kaushik. I think, but CRTC is anything. Nah. You should remember scan copy. Scan copy is there. Then what? Someone scan copy is available. Then respond number 2.
2, my lord, service is awaited, my lord.
Oh. Okay.
They informed me.
Scan copy, okay. Mr. R.D. R.R. Kaushik. Peruse the office note dated 2/8/2025. Close stop. Though scan copy of the case records of PRC case number 3852/2023, as called for, are received, the service report in respect of the respondent number 2 is awaited. Close stop. Release the case after 2 weeks.
Lord, can it be before 21/8, because the next date is on 21.
Okay, release the case. When is the next date?
21/8.
21/8. Meeting?